All right, I think we are all set. I'm gonna call the calendar and then we can map out the way we go through it. We probably have a little more than we can fit in before 10. I have a call I have to get on at 10, so we'll go till 10, take a little break, and then finish up. And we also have a 1 o'clock calendar. So this morning we've got Mr. McClone, positions 1 and 2. Ms. Rios, what are we doing with those cases?
We are taking the plea.
Okay, Ms. Willingham, both those cases are yours?
No, but I'm gonna handle the plea as well.
You'll handle both. Okay, great. And then we've got Sheree Robinson, three cases. Ms. Rios, what are we doing there?
I'm going to tell you a non-negotiated plea.
All right, and Ms. Smith, you've got all three?
Yes, sir.
You ready to go on those?
Yes, sir.
Okay. And then we've got Jerron Reynolds. I've got here, it's to talk about setting aside a bench warrant.
Yes, sir.
Okay. And then Mr. Avery, is it a revocation in both his cases? But you got I didn't share it with you. You got the good news. Drug court said, oh, no, we were thinking of a different Avery. He's in. Well, I think there were 2 Averys and one had a bunch of convictions for distribution. And this Avery maybe didn't have as many. Regardless, we had a warm seance about it and they said, let's give it a try. So I assume that's going to be your recommendation, but we can handle that revocation. And then I think we're going to do Mr. McWell as well. That was supposed to be this afternoon, but for scheduling purposes, you asked to have that go this morning.
That's correct. If you recall, we've already done the plea.
Yep, we're just talking about sentencing and you were hoping to get some paperwork.
Right, we're ready.
Okay, great. Ms. Nelson made me commit to do Ms. Willingham's case first.
Yes, Judge, thank you. I have a meeting that was previously scheduled with Atlanta PD and Atlanta Fire at 2. So.
Well, there you go. That's not who my meeting is with, unfortunately. It won't be as interesting. So let's do Mr. McGlone and then maybe we can squeeze in Mr. McWell and then see what time it is. All right?
2 cars, which is the room, and I hear it was supposed to be
Okay.
downstairs.
Well, tap the brakes.
What I can do, I'll go back over to my side. He's not here yet. But if you guys just give me a call, then I will try and pop on Zoom.
Okay. Let's see if he's here and can be brought up. Let's do that. If he will be here at some point and we just don't want to interfere with your meeting. So Zoom, if it's before 10, it could be that, how long is your meeting?
I'm not sure, but there are other people in the office. So if absolutely necessary, someone else can take it. It's a case where me and Ms. Nix are both on it. So I'll also kind of see where she's at.
Okay.
We should not hold anything up though.
Okay.
So I will make a person available.
Okay, great. What are you hearing? You're not hearing. Okay. Well, darn. So then you should go and Ms. Nelson or I will just be in touch with you. You should let us know. I mean, I don't mind doing McGlone this afternoon if that works better. I don't know what your schedule is like.
Because
Okay.
that was what I said that I can either do it first thing this morning or I know that I will be done for sure by this afternoon. So whatever works at the court.
Well, I don't want, yeah, okay, Ms. Rios, you were gonna be here this afternoon anyway, so that's not dragging you back here for McGlone.
I'm planning all day.
You say that with the enthusiasm I've come to love and expect from you. So let's just do a reset to 1 o'clock today, all right?
Thank you.
You bet. Give my best to APD and AFD.
Thank you. Or I will, I'm sorry.
Yeah. Yeah, I don't know about the thank you part. Ms. Smith, are you ready to do Mr. McWell? All right, let's do that. Mr. McWell, if you'd come on up to the podium. And you can, because we're just doing sentencing, if you want to stay right there for that. If you're going to be up here for the things that follow, you can get situated up there. It's really up to you. They made it sound like it would be today, though. Just they couldn't say, hey, it's the next 10 minutes.
They're gonna be here today.
Okay. Who's the other Cobb person?
Renard
Reynolds, okay. All right, so Reynolds and McClone we're holding on. All right. Oh, let me go. I have my McWell paperwork. I'll be right back.
What's that?
You want to first, right?
It's gonna be 2 years. That's a recommendation. I'm asking for probation. With first offender. Yeah, for sure. And Judge, may I approach real quick?
Sure. Thanks. Okay, let's get back on the record in Mr. McWell's case. It's 25 SC 004117. And last week, Mr. McWell, you entered a plea. So I've accepted your guilty plea. I learned that this is a situation kind of near Greenbrier from June of last year. There was some issue with you and your car. I think it was actually Ms. Brown and her car plus the Watkinses, and you ultimately got out and fired some shots near Bank of America. Fortunately, no one was hit, but I think a couple of vehicles were hit. Those are the trespass counts that I think you damaged some vehicles. We were holding off on sentencing. You have 3 prior arrests, including this one, no felony convictions. So, Ms. Smith, why don't you start for the state? Let me know what the state's recommendation is, and if you've got any victim impact statement from the Watkinses. I don't see anyone online, so, but you may have important info to share.
Yes, Judge, starting with the recommendation in this case, for counts 1 through 3, the state is recommending 5 years to serve 2 with the balance probated. For count 4, possession of firearm during, we're asking for 5 years to run consecutive. And then for counts 5 to 6, we're recommending 12 months to serve. For counts 1 through 3 and 5 and 6 to run concurrent, and of course for count 4 to run consecutive. Special conditions of probation, we're asking for the defendant to complete an anger management course, to have no contact with the victims, and to be gainfully employed. I did have an opportunity to speak with the victims who were shot at that were in the car, and also the victims of the people whose cars were damaged. So the people of the ag assault charges and the people of the criminal trespass charges. Starting with the Watkins, they did not want to be on Zoom or be in person. However, they did tell me that this was a serious crime, and they want the defendant to be held accountable because there was a child in the car. They just asked for updates after we got out of the court, but they did not want to be here. And as far as Ms. Wilcox, she is one of the people whose car was shot. She was inside of the car when it happened. I had a conversation with her, and she said that This has changed her life drastically. She still has a bullet hole in her car that she has not been able to get fixed. Her window was also busted by one of the bullets. She was able to get that fixed, but just not the bullet that's still in the car. She said that because she's not able to afford it, she didn't go to work for a while because she was scared based off of what happened to her. And she's just been trying to navigate life since it happened. She's been kind of taking it hard. I spoke with the other person whose car was shot. They were not in the car at the time. Miss Gordon, she said that she did not want to basically be a part of this process. She would like restitution. However, I have not gotten any receipts or documentation from her. But regarding the victims in this case, those are the statements that they've asked me to relay to the court.
Okay, got it. So 10 served 2, balance probated with the conditions that you mentioned.
Yes, Judge.
All right. Mr. Fortis.
Thank you, Judge. We're seeking 10 years probation. We're also seeking first offender. I know that that's discretionary with the court, but when we did do the plea colloquy, he is first offender eligible, and you indicated you would just take that under advisement at sentencing. So I just wanted to make sure that the record was clear what we were seeking. I'm going to give you a little background. I'm going to give you why I think we're seeking this. I'm going to call his mom as a brief witness. But outside of that, Mr. McWell is 30 years of age. He's lived in Georgia his entire life. He has very strong ties in the community. He graduated high school. He maintains stable employment with Amazon. He's a law-abiding citizen outside of this. This was just kind of a one-off. We'll get to that in a minute. The incident kind of arose out of an escalating situation, not really for him, but for the driver of the car that he happened to be in. And I believe, the alleged victims in this case that were kind of jawing back and forth regarding some erratic driving. And depending on who you want to believe, whether it was the erratic driving by the vehicle that my client was in or the erratic driving by the other individuals in the other car. And that continued on, and we'll get to that in a minute. The evidence will demonstrate that really has not been conveyed to the court, in my estimation, correctly, and that the alleged victim actually significantly contributed to and escalated the confrontation. According to the police report, the alleged victim armed herself with a brick and then challenged the parties to a fight. This was in the police report. This is also statement witnesses that were in the police report. So the alleged victim in the case gets out of the car, arms herself with a brick, threatens not only my client, but threatens the driver. As I indicated, there was an independent witness that corroborated that the alleged victim threw the brick through the rear window of the vehicle, causing extensive damage and contradicting portions of the alleged victim's statement to law enforcement. So what ended up happening is that when law enforcement arrived onto the scene and interviewed the alleged victim in the case, the alleged victim indicated that there was a verbal altercation. That's all it was. What escalated the situation is when the alleged victim gets out of the car, arms herself with a brick, basically says, "Do you want to fight?" and then proceeded to throw the brick through the window. So when the police arrived on the scene, she negated that she threw the brick through the window. And obviously, and I've shown pictures to the state regarding the brick that did go through the window. And not only that, there were independent witnesses that were there that were there on scene and stated that she threw the brick through the window. So in essence, the alleged victim in this case was not truthful to the police. So it caused them to question a lot of what she asserts happened in this case based on her ability when they arrived on the scene to not be truthful about what her actions were. Prior to the big brick being thrown, the encounter was verbal. I mean, that's all it was. And then she escalated it. And one would say, if she's so concerned that there was a child in the car, then which my client did not know that there was a child in the car, regardless, why would you escalate a situation and arm yourself and threaten somebody? And that's exactly what happened. He reasonably perceived, my client did, the situation as dangerous once the alleged victim armed herself, threatened violence, and then acted on that violence by shattering the back window of the vehicle that he was in. While he acknowledges his reaction may have been excessive and he accepts responsibility for the conduct, and that's why we're here today, the facts clearly show that this was just not a one-sided incident where Mr. McWell gets out of the car based on a verbal dispute and starts haphazardly firing his weapon. No individual was struck. There's no physical injuries by the discharging of the firearm. Mr. McWell, as I stated earlier, was unaware that there was a child in the other vehicle at the time of the incident. And I think that if I want to elaborate on that, as Your Honor will recall, I think at calendar call when I had indicated that we were contemplating filing an immunity motion at that time. And I spoke with Mr. McWell at length about that because I think we had a meritorious argument. And I think that not only that we had the alleged victim in this case just not being truthful. However, we talked about was the force, was it reasonable in nature, number one, and number two is I think that Mr. McWell felt, very bad about the fact when he learned that there was a child in the car and not what happened, but more or less what could have happened. So he decided to forego that route and move forward with accepting responsibility before that court, and that's what brings us here today.
So I'm curious, I'm looking at the original booking information just had citations, but there's a much more thorough affidavit from, seeing if it's a detective, some officer, who clearly had done some work on the case.
Yes.
It references one of the Watkinses, with a brick. That person says, I didn't throw it. Mr. McWell turns himself in. You had mentioned that last week. He's like, hey, you need me. I'm coming in to talk. He said that the rear windshield had been broken by the brick, but then the officer says there was no damage to it, looking at an uploaded video, and Mr. McWell could not confirm ever seeing a brick in the vehicle. So we're not trying the case right now, but I'm just trying to work through. It's clearly more complicated than it initially sounded as I look at this affidavit, where we've got one of the victims admitting, I got out with a brick in my hand. She says she didn't throw it. Someone holding a brick is different from someone throwing a brick. And so I'm just curious. You sure can.
This was received by my client, and this is his car.
Okay, I mean, that's a car with a hole in a window. I don't know if it's this car, but okay.
Well, and I can also tell you that there were statements that were gathered independent on the scene, and the independent witnesses corroborated that the alleged victim in this case threw the brick through the back window.
Okay.
Okay. So regardless of what anybody, what the police report may say regarding that, there is corroborated evidence through independent witnesses who were on the scene that saw her throw the brick through the window.
Okay.
Okay. And as the court just alluded to, the court should consider that when Mr. McWell was contacted by law enforcement, he voluntarily went down there immediately to give a statement, knowing, number one, that he may be arrested, but certainly he wanted to let the officers know what his side of the story, was. And when he got there and gave his side of the story, he was subsequently arrested. He was subsequently given a bond thereafter, not at first appearance hearing. We did have a bond hearing before Your Honor. And during that bond hearing, Your Honor put Mr. McWell on an ankle monitor. I would say that he was on roughly about 6 months on that ankle monitor without incident. And then it was removed. During the pendency of this case, he completed 50 hours of community service. He did a firearm and gun safety course. And more importantly, all bond conditions from this court, as you stated from up there to my client, and talked about the seriousness of the event and that we could have been here for something much worse. You basically advised my client of what those conditions were going to be, including the ankle monitor, and he complied with each and every one of those conditions that the court put on him. While he was out on bond without incident, it demonstrates that I don't believe he's a danger to the community and that he is successful. He is capable of being successful in any type of rehabilitation conditions. The state wants him to do some sort of anger violence courses. We have no problems with that. I think that is warranted under the conditions. He does not know these alleged victims whatsoever. He's had absolutely no contact with them either before this incident nor during, nor subsequent to the incident. There are mitigating circumstances to the facts. It's not just that there was a verbal altercation and Mr. McWell jumped out of the car and started firing. I think that one could say that he felt threatened at that point, just whether the response was reasonable or not, and what that reasonableness, is. A probationary sentence under the first offender it adequately punishes him, keeps the court with the tabs on Mr. McWell. I'm sure the court's heard all that before, and being accountable for whatever conditions, the court may put on him while protecting the community and preserving making him being a productive member of society as he has been, by working and helping his family and supporting his family. He has a lack of criminal history. There's no felonies at 30, 31 years of age. He's demonstrated his ability to be compliant on bond, which makes, in my opinion, his ability to be compliant on probation. He's here to accept responsibility, not only through denial of filing an immunity motion, but certainly trial. And I believe that he's got substantial mitigation in this case, not only what he's done on his own, but certainly the facts and circumstances. And I don't need to tell the court that when the police come to the scene and you're not truthful on what your actions were, it leads one to believe or to think, what was really said or what was really done based on the purview that if you were to accept that from the alleged victims. So in this particular instance, Judge, what I'm asking for and what I think is warranted in this case is I think that the 10 years on probation with first offender, with the anger management component, if the court would like any additional community service, Mr. McWell would be happy to complete any additional community service as well, or any of the conditions that the court may deem appropriate. He is holding himself accountable for what happened. I just think that incarceration is intended for those who cannot be rehabilitated or who pose an ongoing danger in the community. I just don't think that his history nor his conduct nor the person that I've gotten to know demonstrates that. And if we think about what is really going to be achieved by incarceration, I think the messaging has been sent, number one. He's taken it extremely serious, number two. And then he gets out, however long that they hold him, and now he's without a job, without a home, without a car. And I mean, yes, those are conditions and circumstances of conduct, but the reality of it is that does this conduct, and based on all the facts and circumstances, does that really warrant incarceration in this case? And I think that and I keep bringing up that based on the veracity, when the police came onto the scene, just calls into question, it raises a lot more questions than answers from the alleged victim in this case. I think a probationary sentence still serves the interest of justice. And I think that this young man will benefit from that, will learn from that, and will continue to grow from that. And I think that that's what the expectation is from this court. And I think it is the expectation from any court, is that what does it look like moving forward? And I think that the fact that there has been no hiccups along the way, that I don't anticipate there being any hiccups during the course and pendency of any probationary period. And I think it's warranted in this case. I'd like to just call his mom briefly,
Okay.
if that's okay.
Sure. And she doesn't need to testify. You can just have her stand wherever deputy wants her to stand, and she can share what you want her to share.
Okay.
Good morning.
Good morning.
You don't have to be sworn in. You just need to tell me your name.
My name is Wanchella McWell.
Okay.
Good morning, Ms. McWell.
Good morning. I'm Sebastian McWell's mom.
Okay.
Okay. And just, has he lived in Georgia his whole life?
Yes, sir.
Okay.
Where was he born?
He was born here in Atlanta, Georgia.
Okay. Grady baby?
No, he's Emory.
Emory baby.
Yes.
Okay.
Tell the court a little bit about your son. What kind of son is he?
For starters, Sebastian is not a confrontational guy. I never had problems out of him. Like the last time he finished high school, went to community college for culinary art. He been on a good path. Before this incident, he was working for this tech company. He was about to convert over permanent. This incident happened. he lost his job. He had just bought his, first car. So
The
his-
car that was in this situation or a different car?
This car right here.
Okay.
He bought it for himself for his birthday.
Okay, who is Ms. Brown to him?
At the time, his girlfriend.
Okay, so she was driving his car.
Yes, sir.
Got it.
And, ever since the incident happened, Your Honor, Sebastian, I think he's depressed about it because after the last time he was here, y'all stated that it was a child in the car. And that bothers him because he loves kids. And, right now, like he's a helper with Amazon Flex. He's doing well. But since this incident happened, it's like he's kind of iffy by, his confidence in the working world right now. And, he's not confrontation. I don't have no problem with Sebastian. And since they put the monitor on him and everything, he's done everything the court asked him to do. No hiccups. So I just feel like he need a second chance because he's not a bad person.
Does he stay with you or does he have his own
He
place?
stays with me, and I got a disabled sister.
Okay,
I work at the job that he was finna get hired on.
Yeah.
I got hired permanent.
okay. Well, congratulations.
Thank you. And he helped me with my sister who's
Okay.
disabled.
Sure.
Because I work a lot of hours. But like her therapy, doctor's appointment, when I can't make it, Sebastian, anybody take Sebastian will take her for me.
Okay, but he has a place to stay then in the form of the house that you and your sister occupy.
It's my home.
Your home and your sister is
She
there.
got her own home.
Okay,
So, but when her doctor's appointment and her therapy come, if I can't make it, Sebastian will go for me.
got it. So your sister lives on her own,
Yes,
but
sir.
you help care for her as does your son, and your son lives with you.
Yes, sir.
Got it. Okay. Well, I appreciate you being here. Thank you.
Thank you so much.
You're welcome.
Judge, I think that's all I have for the court.
Okay.
At this point.
Mr. McWell, anything you want to add?
If it was a child involved, I apologize because that really did like mess with me, especially when I was sitting out. And when I got out and I was on the ankle monitor, it was on me heavy. But now, like, I'm trying to get around the curve, find employment, get over this situation and just move on with my life.
Okay. All right. You can take a seat. You don't have to stay right there.
Thank you.
Ms. Smith, in the warrant that I'm going to say it's Detective Leonce, Leonce, completed her affidavit, she says that this car that now I know is Mr. McWell's car, but that Ms. Brown was driving, was impounded for processing. I'm just curious if you have any information from the police reports. If there was a hole in the back window, it would have been there when they processed it. This seems to be a point of contention. I've seen a picture and you've seen a picture. There's a picture of a window with a hole in it. I can't tell if that's a Kia or not. I don't know that it's Mr. McWell's car. I'm not doubting Mr. Fortis, but anyone could have given him that picture and said, hey, that's the car. I'm curious what your file shows about what law enforcement learned about the state of the vehicle.
Yes, Judge, it was kind of something that was mentioned but never followed up on. Even when the car was impounded, they didn't say much about if there was a brick found in the car or some type of hole that was in the car. When I spoke with the victim, Ms. Watkins, she did say that she never threw a brick. So that was something that she's still saying. But as far as what happened after the car was placed in the property of the agency, they didn't follow up regarding if there was a hole in the car.
Okay, if they photographed the car, those photos didn't get to you and then ultimately to Mr. Fortis.
That's correct.
Okay.
And Judge, if I can just say this, that there, in the police report, there's a narrative by Officer Taylor Washington. And in that narrative, he states this is reading from the report, multiple witnesses, including Lanice Gordon, stated that during the verbal dispute between Asia Watkins and the suspects, Asia did throw a brick into the suspect's back windshield, first while trying to physically fight, and then the male suspect fired his weapon at Miss Watkins.
Okay.
So that's in the narrative.
Got it. And did you say, Ms. Smith, that one of the two, I'm not remembering the names of the two
victims.
car owners, was one of them Ms. Gordon?
Yes, it was.
Okay, so that's the same person.
I'm assuming yes.
Okay, got it. All right. Well, Mr. McWell, I've already accepted your plea, so now we're just sorting out what ought to happen next. I see both sides of this. I don't understand how things spun up this much, and I'm fussing at Ms. Watkins as much as I'm fussing at you and Ms. Brown. But escalation is indeed what happened. People have attitudes when they're behind the wheel of a car, and it sounds like one of the Watkinses got out. That's escalation. And had a brick. That's escalation. Maybe threw the brick. That's escalation. And then someone brought a gun to a brick party and fired that gun. That's escalation in a way that, in my mind, is a whole lot more dangerous than throwing the brick. And I don't condone the brick throwing. I think that Ms. Watkins maybe should be charged for damage to your car and to aggravated assault. That's an assault, throwing a brick at someone. There's this notion of proportionality. Do you respond to that? You being, I'm assuming, larger and stronger than Ms. Watkins, by shoving her to the ground or making sure she stops or calling the police? Or do you pull out a gun and fire it 3 or 4 times? And in my perspective, that was disproportionate, and it further escalated in a way that could have killed a kid, could have killed Ms. Gordon, who had nothing to do with anything. She's just sitting in her car. So I don't know where people were standing and if you were aiming at Ms. Watkins or aiming at her car, but you can see what happens when someone pulls the trigger of a gun. Bullets go straight. They don't go where you want them to go. And 2 of them went straight into Ms. Gordon's car. She's still driving with one of your bullets around, stuck in the side of her car. And none of that is okay. All of that is about as dangerous as can be. The one mitigating piece, and Mr. Fortas is doing his usual good job, is that it wasn't completely nonlinear by you. It's not that Ms. Watkins said, your Kia's ugly, and you jump out and you start shooting everyone. But that she did something that damaged your car. It's a crime, endangered you or Ms. Brown. A brick going through a window is also a dangerous situation. So I get it that it wasn't just Ms. Watkins is minding her own business and you didn't like the way she cut your girlfriend off or the words she said when you guys were fussing at each other. I don't have nearly as much information as Mr. Fortas. I'm not as confident as he is that an immunity motion would have ended with a ruling in your favor and thus the extinguishment of the case. But we're here now. You are taking responsibility. I appreciate that. Here's what I'm going to do, and hear out the sentence, and then know that you still got your final plea right. So you can talk with Mr. Fortas and decide, you know what, I don't want to go to trial. I don't know what will happen then. So this is what I'm going to do. But let me ask Ms. Simpson a question. My recollection, and this was relatively new news to me and maybe to you, is that people can report to the PDC? Yeah, okay. Mr. McWell, I am sentencing you on counts 1 through 3 to 5 years. Count 4 has to be 5 years. It will run consecutive to count 1. 5 and 6 will both be 1 month. And here's how those break down. 5 and 6 are 1 month to serve. 1 through 3 are probated, and 4 is probated. So it's a total of 10 years probation. It's actually 10 years to serve 1 month with a balance on probation. But the first special condition of your probation is that you complete 180 days. That's 6 months. That's half a year at a probation detention center. The second special condition is that you have no contact with any of the Watkinses. It sounds like you didn't know them at the time, strangers to you.
I don't know these folks.
Good. Keep it that way. You don't look them up. No family member looks them up. I don't know if you and Ms. Brown are still talking. She doesn't look them up. The Watkinses need to have no contact from anyone associated with you. I will sentence you as a first offender. Your lack of criminal history justifies that. And I appreciate your mother's information that you're just trying to keep moving in the right direction. But this isn't something that you get to walk away from quite that easily. So to recap, that's 6 months at the probation detention center, but that's something that you report to when they have an opening. So you don't need to go into custody today, should you choose to go forward with a sentence. But you will be notified by your probation officer, and it's usually a couple months wait, give or take. Hey, they've got an opening, and then you report to the detention center, you do your time, you're getting credit for your probation time while you're in there. And then you are back out and hopefully moving forward with work or school or whatever it is you're going to do. I don't see straight probation as an appropriate sentence, non-custodial sentence, I should say. A non-custodial sentence as commensurate with the seriousness of what happened here, even with the provocation. I'm not ignoring anything Mr. Ford has said. I hear it, and it would be a complicated trial. I don't know what the jury would do, and you may decide that's what you want to do. So, Ms. Smith, anything from the state about that sentence?
Nothing further.
Okay. Mr. Ford, any questions about the sentence before you and Mr. McWell discuss it?
Judge, just the 180 days, I think that he spent some days prior to getting a bond hearing.
He did.
Would that time, is the 180 days, is that negotiable based on either A, the time that he spent in jail before he made a bond, number one, and number two, because I know it sometimes varies from 90 to 120 to 180 days, depending on what the court orders.
Right.
And then number two, would the court take into consideration, the 6 months, not the entire 6 months, but to some of the time that he at least spent on the anchor monitor, without incident?
I've thought about all those things. I don't think the state's recommendation was off base in a vacuum. You've helped me understand that it was a more complicated situation and that there were aggravating factors on the Watkins side that helps put into context what Mr. McWell did. And so instead of 2 years, I think 6 months is appropriate. I'm aware of the 48 he did, and he gets credit for those against the month that I sentenced him for the 2 misdemeanors. So he's not going into custody today, but I do, you understand what my sentence is. So I guess the short answer is no, it's not negotiable. That's the sentence that I intend to impose, but Mr. McWell has his final plea rights. So you and he should talk about how this is structured, the fact that he'll get to turn himself in, not go into custody today, and that it's 6 months, not 2 years, and he can decide. I'll respect his choice and your advice to him on that. And if we need to try this, then the state needs to bring the Watkinses in, and we'll learn more about what really went down. And the chips will fall where they do.
Maybe we step outside just for a
Sure,
moment.
of course.
Judge, probably, so this is Miss Tennessee. She's one of our new support specialists.
Hi there.
Hi.
Welcome.
Thank you. She was initially going to be going to Judge Paul, but she also did. So, we're sending her to whoever's covering Judge Paul's case.
I think Judge Baxter is doing a fair amount of that. It'll be a series of senior judges that we bring in on an interim basis while we wait for the replacements, the successors to Barwick and Williams. Yeah, okay, well, that's a home.
Did you know that additional judicial seat has been,
So, meaning the 21st judge, it's a complicated situation. The answer is that the legislature did pass the law that creates a 21st seat, but they didn't fund it. So we would need to find funding, and they don't hand that out. So for now, we're at 20 still. Yeah.
so they said yes, but we're not gonna add y'all.
Exactly, right. There was the feel-good moment of, okay, number 21. And then when it came to funding, they said, you know what, we're only gonna fund 3. And it was the original 3 that had been proposed, Gwinnett, the Middle Circuit, and one other. I don't remember, but not Fulton. So. They're talking, but we could do, if you've got something not particularly long, we could do that before I gotta get on this call.
Well, Frederick Avery is on the bathroom. That's the short one, but he's in the bathroom. How long would it take?
I don't know why she would know. Okay, and Reynolds isn't here yet. So you've got McGlone, but we're gonna do that at 1. Robinson, but that's gonna take a little while.
Yeah.
Reynolds isn't here, so Avery would be quick. Well, I gotta wait here anyway. If we can squeeze in Avery, let's do that.
Okay.
Is that a negotiated revocation or you're not sure?
She wasn't initially. Just do drug words, it's actually drug words.
Yeah, I just need to, you have to do it.
Oh, let me double check.
Eighty-one days. I know the math of the month, that's like 2 months and. Yes. This is just 2. Oh. Just. Okay. And we'll just, I'll just put the language over there. Oh, look, I guess after them.
All right, let's get back on the record in State versus Mr. McWell. Mr. Fortis, you and Mr. McWell took an understandable break to discuss. Does he want to go forward or does he want to withdraw his plea?
Judge, he would like to go forward. I did discuss the court's recommendation, or the sentence rather, and he believes it to be in his best interest. I indicated with him that I was willing to try the case. I talked to him about the same things that we talked about before, which were, some of the pros and cons of the case and the outcomes of the case. I think that this is a good outcome. And the fact that the court's allowing him to enter his plea under the first offender, I would ask for two things. Number one, I would ask the court to consider restricting his record. I can send a proposed order so that when he gets done with this, because obviously he's going to lose his job, but in retrospect, without this on his record, I think that if the court were inclined to grant my request, that I think that he would be actually more employable to would-be employers for probably a better job than he has now. And I would ask the court to consider that. And I do believe that he's entitled to a behavioral incentive date.
Okay. Mr. McWell, I will certainly, and you should send a copy to Ms. Smith. The state rarely objects, but I will certainly enter an order that restricts access to this case. Because you're being sentenced as a first offender, it's not a conviction, which means as you're thinking about going back to school or getting a job, it's not the kind of thing that ought to pop up. An employer ought not to be able to see it. But that employer could right now. But if Mr. Fortis gets me those proposed documents, then I will certainly get those in place. As for the behavioral incentive date, I already thought about that. I think first offender is the right opportunity here. And I think you, Mr. McWell, will control how quickly probation would reach out to me to say, could we just close this case down? If you are on probation the way you have been on bond, probation is very quickly going to get tired of having to supervise you because you're not presenting any challenges at all. And they can reach out, as they typically do when there's a longer term of probation, to say, can we terminate this early? But I'm not going to build in the bid. Given the fact that you're getting first offender, I think that benefit ought to carry with it the ability to monitor things a little bit longer, and certainly to give me the ability, if something doesn't go well while you're on probation, for there to be some pretty meaningful consequences. I hear your mom loud and clear, and basically your life story, that I'm hearing about your one worst moment. And I'm not painting a picture of Mr. McWell as this gun-toting, dangerous guy. Your worst moment just happened to be super dangerous, with a little kid in the car and a completely innocent bystander sitting in a car that got hit twice. That's what's yielding these consequences. It doesn't define you. And that's why I think first offender is appropriate. And that first offender is really not a risk for you. You're not someone who's going to have issues going forward. And so you'll be able to take full advantage of it. Anything else, Mr. Fortis?
No, Your Honor.
Okay. Ms. Simpson, we need to give Mr. McWell reporting instructions. Do you want to meet with him?
That'd be great.
Yeah, we'll get on the record.
His reporting date is May 7th at 10 a.m.
Okay, you live in Fulton County? Okay, so May 7th, and you'll be given a piece of paper, but that's about a week from now, 8 a.m. Don't miss that report date. And to be clear, that report date is you meeting your probation officer. You're going home that day. That's not going to the detention center. It's plugging in with probation so they can figure out, do a home visit, and connect with you, okay? All right, thank you.
Thank you, Judge. It's good to see you.
See you.
Is this Mr. Avery?
Yes, sir.
Good morning, Mr. Avery.
Morning.
Give me 1 second, please.
Um,
Okay, Mr. Avery, we're here on two cases of yours, 24 SC 000015 and 25 SC 001416. You are on probation in both those cases, I believe. Our probation officer just stepped outside, so I'm going to need her to, when she gets back in here, to let me know how much time remains on your cases. But I signed some warrants and petitions in connection with those cases that allege that in November, you picked up a new misdemeanor charge of simple battery and possession of drugs here in Fulton. That's inconsistent with being on probation. You're in custody now and have been, it sounds like, for almost 3 months. And we are working through what the consequences ought to be for these allegations. Ms. Rios, do you know the status of the new charges?
I believe they're just open cases.
Okay. Is Mr. Avery admitting he was arrested for those charges?
Yes, sir.
Okay. And what is your recommendation as to what should happen in Mr. Avery's cases?
Recommend that he go into drug court. We initially, as you know, he was rejected, but now that he's accepted, he's been adamant that he wanted some type of drug help. He actually was accepted also to the Salvation Army, but he was doing well. He just had a relapse. He was working at the Pine Lake City Park and Recreation, doing cleaning and painting and cutting grass. So aside from these new cases, I think he was doing well in probation also. So he understands that he has a problem that he needs to address. He's older and needs to kick this habit to continue to have a good life. He wants to be there for his adult children. So I'm just asking that you let him go to drug court, which is what he initially wanted.
So it would be to revoke, we'll call it 3 months-ish, and then modify probation by adding the special condition of enter into and complete adult felony drug court.
Yes, Your Honor.
All right. Mr. Avery, how old are you?
62.
62. So you're not old, you're just older than Ms. Rios. That's what she meant to say.
That's correct.
Okay. These new charges include an allegation that you put your hands on someone who was close to you. It's a family violence simple battery. My question is not what happened or did anything happen. It's who is that person you are alleged to have done something to?
Well, it was my ex.
Okay. Do you have a place to stay when you get out and into drug court or however we work this out?
I have a place.
Is it with your ex?
No, it's with my mom.
Okay. And your mom knows you may be staying with her?
Yes.
Is that a safe place for you? And by safe, I don't mean is your mom going to hurt you, but is it in a neighborhood that will make it difficult for you to focus on sobriety?
No, sir.
Okay. And does your mom live in Fulton County?
Live in Stone Mountain.
Stone Mountain. Okay. How would you get to drug court? Drug court is near where you're staying right now.
Model.
Mom would drive you?
Model.
Oh, MARTA. Okay, good. And we help with that at the outset as we get you MARTA cards if you are in drug court. So you understand it would be a long commute, but you're prepared to do that.
Yes, sir.
Okay. How long have you struggled with addiction?
Pretty much all my life.
Okay. And what is the particular drug of choice for you, if there's one?
Crack cocaine.
All right. Ms. Smith, what is the state's recommendation in Mr. Avery's cases?
Yes, Judge. In this case, the state agrees with defense that we should revoke 3 months of the defendant's probation and for him to enter into drug court. I did look up the new offense. It has been indicted. It was only indicted for the possession charge. So if we're able to also send that case with drug court, that's fine. So he wasn't indicted on the battery charge.
Got it. Is it right now a non-complex, but it's a repeat offender that will come here, or did it get assigned to elected judges division? While she's looking that up, Mr. Avery, so your November situation is now a formal case against you. It's been indicted or accused. What typically happens, I don't see why it wouldn't happen here, is that will go into drug court as well, but it will be what we call a diversionary track. So that if you graduate from drug court, I hope you will, you've complied with probation, and that case gets dismissed upon your graduation. It's not in drug court yet, so if you get some court notice, you need to go to that court.
Non-complex.
Okay, it's in non-complex now. My guess is it'll get bounced to another division, but that doesn't matter. If we're able to grab it and get it into drug court, then it will be within drug court. So there's no going to other courts. You'll go to court every few weeks to be with the judge, who is your drug court judge. There are two of us. I'm one of them. So it may be that you are meeting with me. That's a coincidence. It's not because you had your revocation here. It's that someone flipped a coin and it's Kraus or McBurney and you got me. But both judges do the same things. So that's the plan going forward. Any questions about that?
No, sir.
So you don't need housing. Drug court's going to need to get medical confirmation from the jail that it's okay for you to be in drug court, so that you're going to need to sign a release so they can get medical records from the jail. Orientation is every Tuesday. I don't know that you'll be ready next Tuesday. Not that you wouldn't be ready, but that drug court might not be ready for you because they won't have the medical records. But I'll let them know that I went forward with the revocation and did require you to complete drug court as a condition of your probation. If for some reason you quit drug court, because it's not a custodial thing, you go home each day. If you quit it, you need to understand that that's a violation of your probation, and there will be different consequences from this situation, okay?
I'm not gonna quit.
Good. I don't want you to quit. Just don't run from it. People relapse, and the people who are serious about their recovery, they relapse and they come back to drug court and they own it. They come in and say, I'm gonna test positive. I had a bad night, I did this, and then we help you work through it. But if you decide instead, man, I relapsed, I don't want to get a positive screen, and you disappear, you're not old, but you're going to be easy to find. And then it gets more complicated. So you're committing to it. Let's get you all the way through it, all right?
Yes, sir.
Okay. Ms. Rios, anything else on behalf of Mr. Avery?
No, you're right, thank you.
So I'll let Ms. Simpson know because she's got to fill out the order. But what I'm going to do, Mr. Avery, because of your arrest in November, is revoke 3 months of your probation in both the cases and reinstate the balance. I will add as a special condition of your probation that you enter into and complete adult felony drug court. And I'm going to also indicate to the jail that you are to be released only to drug court. So if somehow your 90 days expire and they're not quite ready for you, you're going to stay in custody until they can get you on one of those Tuesdays so that you do orientation. And then that day, when you're done with orientation, you go home. You'll go to your mother's house. Okay?
All right.
Any questions?
No, sir.
All right. Well, if you end up stuck with me, I look forward to working with you in drug court. Thank you.
Thank you, sir.
They said, I'm sorry to interrupt you too, but Ms. Wart from Drug Report said she was sending the attorney agreement. Did you get that? Okay, I'll bug her saying, hey, I added this guy. You guys need to go get his meds, and hopefully they get that to you.
I can, I guess in the training agreement, I just add the newest case number.
I mean, that's what we did last time.
I would do that, please. Yeah.
26 SC 002077. Yep.
All right, we're gonna be on break while I hop on this Zoom call. And when I come back out, maybe our friends from Cobb will be here.
Come on out, sir.
Mr. Robinson?
Good morning, sir. Good morning.
Good morning. How are you?
I'm fine, sir. Thank you.
Good.
Thank you for asking. How are you?
I'm hanging in there. Mr. Robinson, you have 3 cases that we're going to work through today. Ms. Rios says that you're prepared to enter a plea. For us to do that, Ms. Smith, who is seated to my left, she's the prosecutor. She's going to put you under oath and then ask you questions about your case, about your cases, your rights, et cetera. You'll need to answer her questions truthfully and completely. And we will go from there. You ready to move forward?
Yes, sir.
Okay. Your 3 cases are 25 SC 003 918, 004 852, and then you've got a 26 SC case that is 001 001. It looks like it's 3 theft-related cases. Ms. Smith, when you're ready.
Thank you, Judge. Mr. Robinson, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can lower your hand. Please state your true, correct, and legal name for the court.
My legal name is Sharay Robinson, Charay. Last name Robinson, Robinson.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you would normally take that you haven't been given today?
Flomax. That's prostate.
Okay. Did you get that this morning?
No, we left.
Okay. You normally get it in the morning?
Every day. Yes, sir.
Okay.
Yes, sir.
Does the fact that you did not get the medicine make it hard for you to
No.
follow along with what's happening?
No.
Okay.
How old are you and how far have you gone in school?
I'm 63, ma'am. I'm 14 years in high school, 2 years college. I graduated with academic diploma in high school.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in these indictments?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
No, ma'am.
And are you satisfied with her services?
Yes, ma'am.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
Yes.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
Yes.
Mr. Robinson, do you remember being arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
No, ma'am.
Do you understand that this is a non-negotiated or blind plea and that the state will recommend a sentence to the court?
Yes, ma'am.
Do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes, ma'am.
Do you also understand that if you're currently on probation or parole, that your probation or parole may be revoked based on you entering this guilty plea today?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes, ma'am.
Do you also understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense.
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by entering this guilty plea?
Yes.
Mr. Robinson, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No, ma'am.
As to indictment number 25 SC 003918, how do you plead to count one, theft by receiving stolen property?
Guilty.
As to indictment number 25 SC 004852, how do you plead to counts 1 and 2, theft by shoplifting?
Guilty.
And regarding indictment number 26 SC 001001, how do you plead to count 1, theft by receiving stolen property, and count 2, possession of tools for commission of a crime?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you do not have a right to directly appeal from your guilty plea conviction, but if you believe that there's some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal?
Yes, ma'am.
Do you understand that that process has to be completed within 30 days from today?
Yes, ma'am.
Do you also understand that you have only 4 days from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this plea?
It's 4 years.
Yes, ma'am.
You misspoke, but it's all right.
Oh,
You said 4 days. Just so you know, it's 4 years.
4 years. Okay.
Good, okay.
Sorry.
She always says 4 years. Just today, the word days came out.
Yes, sir.
You have more than a week to do it.
Yes. Okay, thank you. So regarding the facts for the indictment ending in 3918, on January 17th, 2025, officers of the Atlanta Police Department responded to 1190 Metropolitan Parkway Southwest in Atlanta, Georgia, and also in Fulton County. This location is a U-Haul facility. When the officers got there, they spoke to the area manager, who told the officers that a U-Haul truck was stolen on January 6, 2025, so a couple of days earlier. And they reported that truck stolen on January 19th, 2025. The officers from a flock hit, and because they put out a bolo for that U-Haul that was stolen, that U-Haul that was described was located at 1219 Metropolitan Parkway, Southwest Atlanta, Georgia, also Fulton County. When the officers were able to make contact with the person inside of this car, that person was identified as the defendant in this case, Mr. Robinson. The officers, because of the U-Haul was not rented to Mr. Robinson, he should have known that the U-Haul was stolen, or he was not in lawful possession of the U-Haul. Because of this, he was arrested for the charges we have in front of us for the indictment ending in 3918. For the indictment ending in 4852, in this case, on March 7th, 2025, and also January 16th, 2025. In this case, the defendant entered a Home Depot store that was located at 650 Ponce de Leon Avenue, Northeast Atlanta, Georgia, also in Fulton County. On both of those days, the defendant went inside and took a lawnmower and also some other materials like a compressor and a nail gun, and left the store past all points of sale, and did not pay for the the items that were taken. Because of this, the officers did respond to this location both times, spoke with the manager, and filed warrants for the defendant in this case, who was identified as the person who came into the Home Depot and took those items. Those are the facts and circumstances of the indictment ending in 4852. For the indictment ending in 1001, on November 13th, 2025, officers of the Fulton County Sheriff's Department responded to the area of Joseph E. Lowry Boulevard and Joseph E. Boone Boulevard, Atlanta, Georgia, also Fulton County. They received a license plates reader notification in reference to a stolen vehicle, also a U-Haul truck. This is different from, of course, the first indictment, but that license plate was ran through GCIC and came back as stolen out of the City of Atlanta Police Department. When the officers made contact with the person who was in that car, that person was identified as the defendant in this case, Mr. Robinson. When the officers were able to observe the car, they saw that the ignition of the U-Haul was popped and that a screwdriver was being used to start the vehicle. With these facts and circumstances, the officers determined that the defendant should have known or knew that the U-Haul was stolen in this case and that he was not the lawful owner or lawful registered user of the U-Haul at that time. Because of this, the defendant was taken into custody for the charges we have in front of us for the indictment ending in 1001. Those are the facts and circumstances regarding all of the three indictments we have before us. Regarding the recommendation from the state, there is a global offer of 5 years to serve 2 with the balance probated. Regarding the special conditions of probation, we would just ask for the defendant to complete an anger management course and also to stay away from all U-Haul facilities. But that is all from the state, Your Honor.
What's the origin of the anger management?
That's what she's asking.
The anger management?
Yeah, I'm curious. These crimes don't suggest that. I'm not saying we probably all would benefit from anger management, but we've got stolen truck, stolen lawnmower, stolen truck. Not I hit you over the head with a baseball bat or I threw something at you. So I was just curious what your theory was for adding anger management as a condition.
Well, the conditions that I just stated was the anti-theft course and the.
Okay, well, you said anger management. Yeah, just like 4 days. It's okay. Anti-theft fits much better with these crimes.
I'm sorry.
That's okay.
Long week.
Did you have to take lots of steps to get here?
Judge, I mean anti-theft course.
Okay,
Yes.
all right. No, it's all good. You manage lots of cases. In terms of criminal history, I know there is a repeat offender notice that lists 5 convictions, but I get the sense that there are more. How many total convictions from your count? You don't need to say which one, felony convictions, but did you tote up the total number of felony convictions? Okay, thank you. Ms. Ms. Simpson, is Mr. Robinson on probation right now?
He, just recently had a revocation with Judge Whitaker in February.
That addressed all of these?
I believe 2 were on the revocation order.
Okay,
She continued him on probation. He has 1 year and 2 months remaining on that case.
okay. So we could, if Ms. Rios and Mr. Robinson don't object, address that probation because one of these 3 cases, probably the 001. Sure. Right. Mr. Robinson, I don't want you to be doubly revoked. If you've already been revoked for these 3 arrests, that's done. But if you haven't, then it's just going to come back to you anyway. And so my thought is we wrap it all into business here. But I'm going to let Ms. Simpson look that up while I hear from Ms. Rios.
Yes, Your Honor. Mr. Robinson is 63 years old. He has 7 grandchildren and 1 great-grandchildren newborn great-grandchild. He did complete 2 years of college and is forklift certified. He has struggled a lot with some mental, but mostly drug issues all of his life, and he's never had a program to address these issues. I believe at one point he was supposed to go to Stan, but then he stayed in custody and the bed was gone, so he wasn't able to go to the Stan program. So that was a missed opportunity. And we're waiting on a letter, so he's done all the interview process. But they haven't officially sent a letter yet, but he has gotten accepted to what they said was the Rescue Mission Program. And that is a residential program that he would want to go to. So he would like to be able to go to Stan if they accept him, because he also has been set up with the PAD program for housing. He's been doing a lot of work in the jail. Like when I was going to go see him, he's always other places because he's working in the jail. And that person, because he's been doing such a good job, has given him an opportunity. His name is Zach Collins. He got the number and everything. So when he goes out, he has a job with restoration, recovery, and restoring. And remodeling. So he's eager to do that. So his plan would be to go work there, have housing with PAD, and then do the drug program with Stan. And he said he hasn't had this opportunity. He's 63 years old now. I know his history is terrible. I mean, it is what it is. But I think at this not old, but older age, he is wanting to do better, wants to be in his grandchildren's life and his great-grandchild's life. And he has something to look forward to now that he has a job opportunity, he has a program to get in, and he has housing. And so I'm asking for 3 served 10 months. He spent 2 different stints in jail. And we were trying to discuss in the back, like, those stints in jail, would they be applied to all of the cases? Because
They wouldn't. I've looked at it. He has 328 days that would apply to 918 and 852. So there's your 10 months. It just have to be a different sentence if you're advocating for him to be released soon. For the 001 case, he's got 168 days. So let's call that 5 months. So if I were following along with your recommendation, it would be 10 months to serve on the 25 SC cases and 5 months to serve on the 26 SC case.
Yes, that's what I'm asking for, Your Honor. 5 months on 25 and 10 months on the 10 months on the 10 months on the 25 and the 5 months on the 26 case. So he can not, he's really concerned just about missing these opportunities. And I'm just hoping we can give him one more chance I know he's had chances, but he hasn't had a program along with the chances. So I think that's the difference in this situation.
Okay, I appreciate that. Ms. Simpson, were you able to determine what the basis for the revocation was with Judge Whitaker?
So Judge Whitaker had actually addressed all cases. The first 2 cases were addressed in June, and she continued him on probation. And then the 3rd case was addressed in February of this year.
Okay.
So all offenses have been addressed.
And her result, the result of the most recent case was to just give him credit for time served or to revoke him for some time?
Received credit for time served. I'm assuming so, because all she really stated was that, okay, yeah, he got credit for time served from December 8th, 2025. This is as of the last revocation.
Okay.
He was revoked 90 days with credit for time served, and then continued on probation. She removed the conditions of the STAND program and just for him to random alcohol and drug testing.
Are you able to tell from looking in Mr. Robinson's likely lengthy probation history if he has had any programming like STAND or MADRC or?
He was supposed to do STAND. When she had the revocation in June of last year, he was actually revoked into the STAND program. Ms. Rios was trying to explain there was a situation with that. So I don't believe he actually made it to that program.
Okay.
As far as.
What's the what's the indictment, the Judge Whitaker case?
23 SC 190-253.
Thank you. So Ms. Rios, what's the story with Stand the first time around, if it was the first?
It was, I believe it was the first, there was no bed available, I believe, and so he was in custody, and so he wasn't able to go since the bed was gone because he stayed in custody. That's my understanding.
What happened with, excuse me, good morning, sir. What happened with the situation, it was a default by not having a transport order in. Samantha Trebido, whatever her name was, my attorney, and the sheriff department, Fulton County Sheriff Department. So on July 17th, my bed space was, on June 3rd, she sent a bed space was gonna be available at July 17th. They don't pick you up. That I would had to been delivered to Stan at that time. And when July 17th came, Miss Robin Peters, who is the coordinator there, intake coordinator there at his place, stated that your order we don't come get you. Some don't transpire. You have to get in contact with Miss Trebido or your probation officer, which is Mr. Clark. So I talked to them. I called them and talked to Mr. Clark, who is my PO at the time, and still is rather, and mentioned to them, I said, there's a transport order paperwork is mishap. So then he said, well, I got to find out whoever the supervisor was, Miss Joyce, of the community supervision. I tried to contact her. She didn't ever reply back to the phone. So I went back to my PO. He said, well, I don't see what would take place with it. That's something that they would have to speak up on your behalf. So then 2 days later, I received on the case number, the True Bill situation. I went to court for the SC 25 SC 003918 case. That case, a court appearance pulled up. So it gave me a court date for August the 4th. So when I went to court August the 4th, that's when I got a bond. I was on a no bond status. I received a bond.
All right, you got out.
And I got out. I got out on the bond. August the 7th I was told there was a true bill. I have when on the release, it's showing that the cases were the drop by warning, all of the several cases. I had the paperwork that I wanted to give you and show you, let you read it, but she told me you had in the Odyssey. So anyway, so when I asked Miss Peters about the situation, she said, well, you missed your bed space ability. So on August the 4th, when I went to court, I went on and tried to make an attempt to bond out. So I didn't get a chance to bond out until August the 26th. That's when I bonded out, sir.
Okay.
And then she asked me during the interview, why did I not continue my effort with Stan as far on the outpatient issue? I said, because I received information from Ascenda Health when I was going. See, right now, sir, I'm 13 months clean. And I was going to Ascenda Health on the outpatient, which is St. Jude's. And my home group is Home Sweet Home at Covenant Community. So when I was attending over me, they said you got to be referred. That was the situation as far as getting in-house treatment. I had to be referred. I didn't know that I had to go through all that again to come back to the courts.
Let me ask Ms. Simpson another question. Ms. Simpson, the sentence in the Judge Whitaker case, the case ending in 253, there were two special conditions of probation. One is sentenced under POM. I don't think we do that anymore. And the other is balance of probation suspended upon the successful completion of the probation substance abuse program. I'm not familiar with what that is, but I'm curious if Mr. Robinson did receive some programming. This would have been, he pled in February of 24, so that's over 2 years ago. Is there anything in the system indicating that he plugged into some kind of programming?
The only thing that I see is where he did, Better Ways for a different, I think that was actually before. you, and he entered but never completed, I'm not sure if he completed. But that as far as the leave treatment. Okay, I see. It looks. You may have been, because I see he was under Department of Corrections, I see. Judge, can you give me a disposition date?
Yes, it was February 21, 2024.
Um, Yes, so he was in the Department of Corrections under a different sentence. So he didn't actually make that treatment unless he got it while he was in custody, but he was actually under a Walton County sentence around it.
Got it. When he pled in front of Judge Whitaker, he had other business going on.
Yes.
Okay, thank you. Ms. Rios, anything else on behalf of Mr. Robinson? All right. Ms. Smith, I didn't see a recidivist notice. The indictment ending in 852 invokes fourth or subsequent shoplifting. So we're operating under that, but there's no other recidivist provision you're seeking to enforce? All right. Mr. Robinson, I find that there's a factual basis for your pleas in each of the three cases. U-Haul truck number 1, which is January of last year. The shoplifting from Home Depot, also January from last year. And then U-Haul number 2, one with the screwdriver in the ignition, that was just a few months ago. That would have fallen well within your 13 months of clean time. I also find that your pleas are knowing and voluntary. By knowing, I mean you've understood what we talked about, and voluntary means that you're entering these pleas of your own free will. You've decided, hey, I need to move forward. I want to enter a plea. Do you agree with both those things I just said?
Yes, sir.
Okay. Ms. Rios, can someone in my office sign I think one of them is an accusation, but the 3 charging documents for you?
Yes, sir.
And Ms. Smith? And Mr. Robinson, is it okay if we electronically sign your name indicating your plea in the 3 cases?
Yes.
Okay, we'll do that. Here's what I'm going to do, Mr. Robinson. Well, first, I'm hoping that you soon age out of whatever's going on in your life, because getting locked up doesn't change it. You've had some smattering of help here and there, whether it was the program I sent you to a while ago or this or that. I don't get the sense, although I don't know because your history goes back so far and it's in other jurisdictions, if you ever had some treatment you couldn't walk away from. But you've clearly been wrestling with something that keeps you getting in trouble again and again. Not in scary ways, stabbing people and hurting little kids, but still ways that are real disruptive to the guy who owns the U-Haul place or the people who run the Home Depot store, or there have been some burglaries, so people's homes or people's businesses. And gosh, it's just happened so much in your life. I'm hopeful that your body eventually tells you, Robinson, stop. You got to be with your grandkids, be with your great grandkid, be somewhere, but you got to knock off the other stuff that's going on. I am going to follow the state's recommendation, and I'm also prepared, assuming you guys want to waive, except there isn't a probation thing for me to deal with. I don't need to mess with your probation. You're all set with Judge Whitaker. But before I break out your sentence in each of the cases, this is happening at a time where you can say, no, thank you to the sentence. And then we'll just keep moving your cases forward towards trial or something else. So you understand, you will get credit for almost a year in custody for two of the cases, 330-ish days, 11 months almost. Your sentence on the third case ending in 001, I'll make a little lower so that they move in sequence. But the sentence you got from Judge Whitaker was 5-2. And since then, you picked up these three cases, at least one of which was during this window that you said, I was clean, I was sober. And yet you're driving a U-Haul with a screwdriver in the ignition, which tells me we can't blame, and I'm not saying you're blaming it, but this can't just be Mr. Robinson has this real bad addiction, and in order to feed the addiction, he's got to engage in these thefts and these stolen cars, et cetera. Because by your own words, November of last year, you were healthily in this great window of many, many months of sobriety. So I appreciate that someone has once again lined up an opportunity for you. I'm fine saying that when you get out, you should do the Metro Atlanta Day Reporting Center, which is job skills, job readiness, drug treatment, et cetera. But that would be what you'd get to do after you parole out for the custodial term that I intend to impose. So why don't you two talk about it? And then, Ms. Rios, you can let me know if Mr. Robinson, while not thrilled with it, wants to go forward. And if he doesn't, we withdraw these pleas and we'll figure out which one of these you want to have moved to a trial calendar sooner than the other. We'll move all three of them together, but figure out from the state, I guess, which one they'd want to try.
Just so I understand the sentence we talked in the back, you would, for one of the cases is 2 years, but he would get credit for almost a year. So we're looking at him staying in custody for 1 year.
Right, if he didn't parole out. So, and I need to do the math in my head, but when I flagged for you, there's 160 days he did in connection with U-Haul 1 and the lawnmowers. That occurred before he was arrested for U-Haul 2. So he cannot get credit for that. And so the sentence for U-Haul 2 would be, the custodial time would be a half year. It would be 18 months. It would be a year and a half. And that would ensure that really what's driving it is the 2 years on the first two cases, for which he'll get about a year's credit. And then he gets to engage with Department of Corrections on what does parole look like for me. And it may be you don't parole out because of your criminal history. It may be that you do parole out because, as I've already said, these are, in the grand scheme of things, not particularly serious felonies. Your problem with parole won't be the seriousness of the offense. It will be the extent of the criminal history. So you two need to talk.
Well, we can talk, or do you have a question you ask before we go back talk?
Even you're going to come back out here and Ms. Rios says, he don't love it, but he's going to do it, or nope, we're going to try something different and go to trial.
Yes, Your Honor. For one, again, my name is Sheree Robinson, sir. I understand what my history looked like. I understand. I have no way to get the information or gather information about the situation that I pleaded guilty to. In this situation, I have a job. All I got, Mr. Collins told me as soon as I got the verification, the number and everything for me. I never had employment really in the last 10 years or so. I know the choices that I have made were not wise choices. I understand and I appreciate you taking consideration and looking at those scattered situations where I was getting help. I did this on, stuff on my own, is trying to get help on, and I been battling such situations. I'm finna be a new father as well. That's 3.5 months. And the past situations has helped me out with my housing, even though I do have a place to go. The stipulations from the stand program, I would like to go, I have interest in going in that program. Judge Your Honor, at my age right now and under the circumstances, again, for the life of my master, for mercy on this courtroom, because I don't think I'll make it out of there alive. Just be honest with you. At my age, I'm not a gang affiliated member, none of that type of stuff that's going on in there. I'm seeing situations now here at the jail as well, because I'm all over the jail doing work, the stuff that I'm doing. I don't want to subject. I know what that looks like. My record, the history, that's what's been hindering me. I think the light bulb has come on for myself. I understand what it looked like. Like I told you, I was going to my meetings, even though I messed up. And the circumstances with this last vehicle, the circumstances are something that it was another. I couldn't leave my fiance in it. It wasn't, like I said, this is stuff I would have to prove in trial. You know, understand?
Well, and that's what you and Ms. Rios should talk about. She can give you her thoughts about.
But I'm for the life of me, Your Honor, and all your court representatives, I just, for the life of me, don't send me to prison.
What was the last part?
For the life that's left in me, sir, don't send me to prison.
Okay.
Please send me.
I appreciate you sharing that. You and Ms. Rios need to talk, and I will wait to hear back from you. Where do people go for the probation detention center? Mr. McWell, where does?
They're gonna give him a reporting date. He'll come on that day, he'll come to the registry. He won't go in custody. They'll probably put him like a holding place or something. And then the GDC van will come and pick him up and take him to whichever facility.
Interesting. Okay. But it's GDC that does it and not DCS?
Because it's a GDC facility.
The probation detention center. Hmm.
So they're gonna stay in the transit.
Is it, have you been to a PDC before as a guest, not as a,
I've been to one.
does it just look like a prison? Is it lower key?
Outside it does, but it's not as restrictive on the inside.
Which makes sense.
Because I'm not saying they have free range, but it's just not as restrictive as it would be for a state.
Fewer big clanky metal doors you can't get through kind of thing, but you can't leave.
That's correct.
Are they all over Georgia or there are only two?
They're all over Georgia. I believe there are about 5 or 6.
Okay. And did you tell him what the rough wait time is? He was sad.
Yeah, it was even sad.
Yeah. Reynolds is the only other one for this morning, and that's the bench warrant set aside? Okay, we'll do, you're not doing McGlone, but that got moved to this afternoon. Do you have anything on the afternoon calendar? Oh, and then Larry Walker's coming back. Okay. Was he on the trial calendar?
Yes.
Yeah, we do have open contact.
Excellent. Good. Well, McGlone, we got to do it the afternoon now. But once we find out what Mr. Robinson wants to do, we'll bring Reynolds out and then we're done for the morning. And we'll pick back up.
All right, we're gonna go forward to the trial calendar.
Okay. Let me check one.
You want to say something on this?
You,
Okay.
you can tell me something in just a second. I want to make sure I'm giving you good info about when I will see you next. All right, you are set for our August trial calendar. You'll have a final plea date in July, probably, although that day is not sure what we'll be doing in court on that day. But your case, and we'll move all three cases together, assuming there are no discovery issues or anything like that, will be an August trial calendar. You wanted to say something?
Your Honor, I would very much like to take care of this case today, but I just, for the life, I'm scared of this. I'm fearful, very fearful, so.
I respect that. And
You know,
keep in mind,
I'm
it's three cases. It's not one case. It's three cases, which would be felony convictions, if I'm remembering correctly, 17, 18, and 19, while you were on active probation. I'm not trying to minimize life in custody. It's not simple. It's not easy. Someone with your degree of self-control and skills will become an orderly at the Department of Corrections right away. And you will be able to do many of the things that you're doing right now at Rice Street. But like I said, I don't want to minimize it. I will add that there are plenty of inmates who are in your age range. There are also plenty who are younger. But if you maintain yourself the way you have remarkably been able to do it for almost 6 months at the county jail, you'll get through it. You'll be back. You will have apparently a new kid, if I heard you correctly. Forget about grandkids and great grandkids, but a new kid at age 63. And you'll be able to move forward. But I don't make those decisions for you. I'm well aware that prison is not where people want to go. But I also have a responsibility to handle cases in a way that I think is appropriate given the totality of the circumstances. Not one case, but three. Not your first conviction, but your 17th conviction, 18th and 19th. Some of them during a time when you said you had controlled the addiction. So I don't need to repeat it. You know where I come down. That's where I am. And
Take off.
Are you taking it now?
Take off.
Okay, he wants to accept the plea.
okay, then let me pronounce the sentence, make sure I'm following through on my word to you. Your sentence, Mr. Robinson, having decided that you want to go forward with your pleas on the case 25 SC 003918 is 5 years to serve 2 years with a balance on probation. You will get credit for at least 328 days. I think that's the right number. If it's more, you'll get credit for that. It's at least 328 based on my read of the system. Your special conditions of probation will be to stay away from all U-Haul. I don't know, we call them dealerships, stores, U-Haul locations, as well as all Home Depots. I will have you submit to a drug and alcohol abuse evaluation so that if probation recommends any treatment, you get that treatment and that treatment becomes part of your probation. Your sentence in 25 SC 004852 is the same. It's 5 years to serve 2 years with the balance on probation. You get credit for that same amount of time. And it's the same sentence for, is it 2 counts? It is, okay. Oh, because of the March date, right. I didn't turn the page. Same sentence. And you will again need to stay away from all U-Haul facilities and all Home Depot stores. And finally, in 26 SC 001, your sentence on count one is going to be 5 years to serve 18 months with the balance on probation. And your sentence on count two will be 6 months to serve. Is possession of tools for a crime, is that a misdemeanor or a felony? Oh, it's going to be 5 years to serve 18 months. So same sentence as to those two counts. They'll run concurrently with each other. So 5 serve 18 months, balance probated. And you'll need to stay away from U-Haul places as well as Home Depots. When you are on probation, you'll need to submit to a drug and alcohol abuse evaluation and follow any treatment that is recommended. Did you have anything else, Ms. Smith? There was nothing about restitution. I don't know if they got the lawnmowers back or they're not going there. Okay, all right. Ms. Rios, anything else?
Can we put the dates in the disposition to make sure, because I know the jail has been having issues.
We will. I got them right out of Odyssey. So I just did the math, adding up the figures.
All this run concurrent.
It runs, he just wants to clarify that it runs concurrent with his current probation.
Yeah, so two more things. These three sentences run concurrently with each other. They're not consecutive. There's nothing about what I just said is consecutive. All the counts in an individual indictment run concurrently with each other, and then the three indictments or charging documents, those sentences run concurrently with each other. Your case from Judge Whitaker, that clock has been running since you've been in custody. So that probation clock continues to run, and it will run while you're in custody. When you get out, if you get out before your probation is done, it sounds like you will, then you'll just be on probation for Judge Whitaker's case and these three cases. One probation officer, 4 cases. And it's my hope, Mr. Robinson, that you are where you say you are. And you speak very well about it. You need to live it. And that is someone who's ready to work and be there for 3 generations of offspring, and not get mixed up in this stuff. I hope you're ready to turn that corner. You're certainly at a good age to be doing that. Thank you and good luck.
I think the only people we can do next are Reynolds, because McBurney, we're waiting for Jasmine, Xavier, we're waiting for,
Yeah, well, and he's on for 1 anyway.
Okay.
And so I wasn't but Ms. Williams wasn't booked until 1. So why don't we handle Mr. Reynolds, please?
Did I email did you receive the proof of incarceration, Judge? Reynolds, here's a copy. And he was, Miss Court, he was in Douglasville.
Okay, no, that'd be it. As long as Ms. Smith has seen it,
Okay.
I trust you. I got your, in a different case, your paperwork. All right, we don't need to get on the record yet on this one. Let's just have a conversation and see where it goes. You're Mr. Reynolds?
Yes, sir.
All right, Mr. Reynolds, you've been indicted for armed robbery and carjacking. Not our typical case. I'll pull your case up here. You missed court at some point, and it sounds like Ms. Rios is gonna show me that you missed court not because you were running around playing Madden, but you were in jail somewhere else. But let me look at your situation. Okay, so you had a final plea in October. Whoa, this is from a long time ago, October 2024. You were supposed to be in court for final plea, didn't make it, and I signed a warrant. I guess that caught up with you a long time later. So I guess I need to hear about how you missed it and then how you managed not to resurface for 2 years. Let's start with how he missed it and then what's been going on the last 2 years.
He missed court because he has been in Douglas County since October 16, 2024, and he has not been released since then. He just been transferred over
Oh,
here.
well, that would explain it then. You haven't been able to come to court if you wanted to. You've been at the whim of whatever sheriff's custody you were in.
Yes, sir.
What's been going on in Douglas?
I had a gun possession and marijuana charge.
Okay, and have
Did
the,
18 months there. I just finished it on March 10th and I was released April 9th.
okay, so you pled there
Yes, sir.
and they gave you 18 months
Yes, sir.
and you served them not in state custody, but at the Douglas County Jail?
Yes, sir.
Okay, that one's done, and that released you to the hold here.
Yes, sir.
Got it. Okay. All right. And so you are asking, Ms. Rios, that Mr. Reynolds be returned to his bond.
Yes, Your Honor.
Do you know if his bond is still in effect?
I couldn't tell. Let me look in the, see, check now, real quick. Looks, because I'm not always able to tell if it's been, they came off of it. Because I think it just has been for it. Do they notify anyone when they come off the bond?
Sometimes. I'm going to find out the number we call. There's someone at the jail that you want either emails or calls because they're able to look. Sometimes it's in Odyssey.
A lot of times it's not, because, yeah.
Well, sometimes there's something in the docket easy to see, but there's also, you can go to bonds and sometimes it will show if it's been surrendered, but that's body. So you had a $60,000 bond from 24/7 One Call Bonding Company back in 2022. While we're waiting on getting that info, do you, Ms. Smith, have a perspective on whether, clearly Mr. Reynolds didn't intentionally miss court, but while on bond, there's this Douglas County case. I don't know if it's charges that arose before he got this bond or if it is now a conviction that he got since he was on bond for this case.
We did try to look into when that Douglas case happened, but I'm not sure it happened before. I think he was on probation because he wasn't incarcerated at the time he was supposed to be here. I don't have an issue with setting aside the bench warrant. However, we'll kind of work swiftly, try to get this case resolved.
Okay. Is it a case that you think is resolvable as you look at the facts, or the charges aren't ones that?
Last time it was on court, I know I was missing a lot. I remember I was reaching out. It wasn't you. I can't remember who we had at that time, but I was trying to figure out how it was being connected to him because I didn't see, like, it was very limited. Just there was a video, and then I'm just like, where is the connection? So I think that was what was going to be talked about the next court date, but he wasn't here.
Judge, the Douglas County incident happened October 16th to 24th.
That's the incident date. 16 Oct 24. Okay. All right. So since we're all together, Ms. Rios, tell me why, let's assume the bond hasn't been surrendered. Why wouldn't Mr. Reynolds's now conviction be a violation of his bond conditions?
I mean, yes, I mean, the getting arrested would be a violation of his bond conditions, but I would say that he would not, that's one of the factors, but as far as other factors, I don't believe besides this, he had an extensive criminal history. I'm not sure what happened with the Douglas case or why he pled But besides that, and then as far as missing court before that date, he called me like every other week. That's why I did, I believe at the time, try to ask, I don't even think it was Miss Simpson that we had back then, like who, can you look where where is he? Because he was so good at being in contact with me. And he came to every court date. He never had a bench warrant before. So I thought it was super weird for him not to show up, but I just couldn't figure out where he was located. And his phone was off at that time because he was in jail. So I don't believe he is a risk to reoffend. He's not a flight risk. He has family around. I've been talking with his uncle. His uncle's the one that actually called me to let me know that he was in Fulton County Jail and if we can get him a court date. So he's not a flight risk. He's from Georgia, has family ties here. I don't believe he's a risk to reoffend besides these two cases. And he's not a risk to miss court. So I believe, even though he has that one thing, I think everything else shows that he wants to resolve this case. He was very good. We went over discovery I did have. He was very eager and helpful with trying to figure out how he was getting connected in these charges.
Okay. And this case was getting close to a resolution point, because again, it was on for final plea. It sounds like at final plea, we would have had a discussion about your concerns about there being some deficiency in discovery.
Yes.
Just before then, a week before the final plea, now we can name names, Ms. Nix provided more discovery to you. It was cell phone location data and investigative report. So I don't know if you hadn't had a chance to go through it before the final plea date, because there were lots of cases then, but you did get belatedly, but before final plea, another slug of discovery from Ms. Nix.
Yeah, I think I was still having issues going. I think I did look at that, but I still had questions. And I was waiting to get him in court to actually talk to her sometimes,
Sure. Okay. All right. Mr. Reynolds, anything you want to add?
No, sir.
Okay. Ms. Smith, anything from the state?
Yes, Judge, since we confirmed that Douglas County case happened after we observed this case, I would at this point object to the bench warrant being set aside, only because it is a direct violation of bond. Committing a new charge with a gun charge while being on bond for a crime that involved a gun. We think it's kind of concerning for the state, and also could be that he could increase to this case.
Okay. Well, he did. That's part of it. So, Mr. Reynolds, I'm still going to figure out what the status of your bond is. Did the bonding company surrender it or not? And that has nothing to do with you. That's not a good. Yes, sir.
May I speak? Well,
You may.
I did talk to them when I got to Fulton County.
Mhm.
They didn't come off the bond, but I know you got to confirm that.
Okay,
with them.
great. But if they said they didn't, I trust them. They would let you know. I need a refresher anyway on how to do it. You're not going to be the only person I'm working with where, man, but that was a long time ago. Let's see if they're even still on the bond. I'm going to keep you right now in custodial status. We'll figure out whether they came off.
I'm sorry to interrupt. Please check your Teams.
Okay. Oh, I hadn't fired that up yet today. Thanks. So Ms. Nelson knows who to call at the jail, and jail says they did not come off the bond. So that's good. Not good is this Douglas County situation, which in particular involved a gun after you had been indicted for, given a bond for something which, if proven, of course you're presumed innocent, involves a gun and some pretty serious offenses. So what I'm going to ask Ms. Smith to do is to connect with Ms. Rios about the discovery. If there were, I don't even know how that works. Would you have downloaded it, or are you now going to say, Ms. Rios, the evidence.com link don't work anymore? Because of course that was 2 years ago. And why would you have been looking at it last year?
Yeah, I probably need a new link.
Okay. Let's do that. And then Ms. Rios, just let me know, email to Ms. Smith, Ms. Nelson, and me, if there are discovery issues. If there aren't, then let's get this back on a trial calendar. His final plea rights are intact. But if it is one where you think you can get your arms around the discovery and there aren't missing pieces, then I don't see any reason why we can't get because you hadn't filed any motions, which unless there's something in the discovery you didn't get, means that it is either a final plea or it's a trial. And we can make that happen on one of these upcoming calendars before we have the big transition. Okay? All right. Mr. Reynolds, Ms. Rios will talk to you more about what those dates look like. She needs to get that discovery again, and then she'll have a chance to digest it, and then she can get with you about strengths of your case or weaknesses of your case and start counseling you on how best to resolve this. You should know that the time that you did in Douglas would be credited towards whatever. I'm not saying you need to plead to anything. It may be the state dismisses your case or you go to trial and you're acquitted. But as you and Ms. Rios are talking with the state about what's a reasonable resolution, because that time in Douglas occurred after you were arrested in this case, you'd get credit for all that. You can factor that in as you all are discussing it.
Just to make it clear, when he get credit, even though he was out on bond, he would still get credit? 'Cause he got-
That's my understanding. We should look at that statute in Title 17, but we've had to lowercase l litigate it, not like go up on appeal. And time in custody, regardless of the reason for it, that occurs after the date of the crime is custodial time. And so if, in some ways it makes sense. If the state were to say, gosh, Mr. Reynolds needs to do a year because of this case. Well, he has. He happened to do it in Douglas County, but since he allegedly did what this case is about, he did a year. And that's what the statutes, and it's how the court has been applying it. And I don't think it was amended in the recent session. I think the only thing that was amended in the recent session is on the probation side, where now people need to get credit. They can't not get credit for time they've been in. When a judge says, I revoked 10 months, if they were in for 9 months, DOC has to give them credit for those 9.
That was fixed?
Legislatively, it was.
Oh, when did that happen?
This session.
Oh, I didn't know, okay.
Yeah, and I don't know that the governor signed it yet.
Oh, okay.
So we may need to wait till July 1, but that piece of legislation, I believe, passed.
That's great. That was stupid.
Well, they clearly heard you on Capitol Hill. This is how powerful your lawyer is. She says it's stupid and the legislature changes it. So I will see you soon, Mr. Reynolds, whether it's because you all have worked things out or Ms. Rios may find something in the discovery where, hey, we need to litigate this, and she files a motion or trial, one of those things. Okay?
Yes, sir.
All right. Thank you.
I'll see you soon.
In court that day, and I told you to do that. No, I don't know, we got an email. So then, center, yeah, so we didn't get that actually.
All right. We will reconvene at 1. At that time, we will take care of McGlone and Wells, and we'll see if Walker shows up. You need me?
Now, old case numbers that start with Y, does that mean youth? Or
No,
is
it's just indictments, back when I was an ADA, why, for whatever reason, it started with A before my time. So A, 1, 2, 3, 4, and when they got to 9999, then they went, for some reason, they went to Z instead of B. And so you will see some Z numbers, and then Y was the last one until they started saying, why don't we put the first 2 digits of the year? So I don't know when it transitioned, but like O1 SC 1, 2, 3, 4, then you know, okay, that's an indictment from O1. But an indictment that says Y 1, 2, 3, 4, that's has nothing to do with youth. It just is that was the bizarre clerk numbering system.
So if you look at Walker,
Yeah.
at the last one, um, that's his cycle 1 is a probation violation with problems in that case.
With the Y 23055.
It's a probation violation.
Weird. Yeah, how could it be your first cycle?
Yeah.
Yeah.
I've never seen the first cycle say probation violation with the charge.
Okay. He's on for a bond revocation. He's supposed to be going to trial. He rejected the plea because it sent him to prison. He don't want to go to prison. So it's good to have this, but our focus is going to be on, he was supposed to move out of the home with the kid that he's allegedly beaten.
I remember him.
Yeah. We almost did the plea. He was in here forever.
Yeah, I remember that day.
Yeah.
There was a lady with him, and
Yeah.
another kid.
Yes,
That wasn't
yes,
his kid. I remember.
yes,
Okay.
correct.
See you everyone.
All right, man. Enjoy break. Ms. Rios, did we get our fork back?
I did, I cleaned it too.
Thanks. All right. Let's get moving with the afternoon calendar. Tell me what the plan is, Ms. Rios, with Mr. Wells.
That is a plea.
And who from the district attorney's office? Hello, Ms. Williams.
Your Honor.
You're handling both those for purposes of the plea?
Ms. Smith is going to do the facts of her case, but I'll do call.
Okay. And then we've got Mr. Walker, to handle the motion that you filed.
Actually, Your Honor, I think we're gonna be able to resolve everything with the plea today.
Okay, then we'll have a conversation with Mr. Walker and his lawyer and you. Mr. McWell, we handled this morning, and we have a carryover from this morning of Mr. McGlone. Is there a particular order in which you wanted to do things because family's here, or?
His family is here.
Do Mr. Walker first? Okay, Mr. Wells is here, just in custody?
Yes.
Okay, and McGlone came this morning, so, okay. Does that work for you?
Yes, Judge, and, Mr. Wells' case, I filed an accusation, so I'm still waiting on the number to pop up for that.
Okay, well, that'll give us some time if we turn to Mr. Walker. So, Mr. Walker, come on up, please.
Oh, yeah. Since I found it. Oh, yeah. Yeah.
All right, I have some letters that look like those were with you.
Okay. Thank you.
Yeah, after she speaks, and then I will speak again, and then you can talk. What do you want to say? You have questions for him? He's gonna talk. Okay. have it.
Ms. Rivers, are you ready? Okay, well, let's get on the record then. This is 25 SC 007 409, State versus Walker. Good afternoon, Mr. Walker.
Good afternoon, Judge.
Mr. Walker is here with his lawyer, Ms. Rios. We have Ms. Williams from the state. And this is a case that we've already had a fair amount of discussion about. Mr. Walker tendered a plea before, but it was when he had his final plea rights. And after I heard from the state and Ms. Rios and saw some pictures, I imposed a sentence with which Mr. Walker disagreed, which was his right. It was higher than what Ms. Rios had asked for. And so we unwound everything. And so we have to do it all over again. Some of it may go a little faster because I'll have some familiarity with the case. But Mr. Walker, what I'm understanding is that you want to enter a plea again. Is that correct?
Yes.
Okay. Now, what's different this time is that I can accept your plea, but whatever sentence I give you is the sentence you get. You don't get to say, no, thank you this time. As long as it's a legal sentence, it's not going to be an illegal one. If I sentence you to 400 years, that's higher than I could, and that's not going to happen. But right now, the sentence I impose, it would be as if you had gone to trial and you were found guilty. If you went to trial and were found guilty, you don't get to say, I don't want that sentence. So I will still hear from Ms. Rios. I'm going to make sure I look at these letters. I'll hear from you. There may be people here that Ms. Rios thinks I should hear from. But in the end, I'm going to impose a sentence. And if it is different from what Ms. Rios asked for on your behalf, it's still the sentence that you have. Do you understand that?
Yes.
Okay, that's different from last time, but it sounds like you get it and you still want to go forward.
Yes, sir.
All right, then that's exactly what we're going to do. Ms. Williams will put you under oath, ask you many of the very same questions from before, and then I'll hear from Ms. Rios and you, and we'll see what happens, okay?
The negotiated plea, Your Honor.
Okay,
Mr. Walker, please raise your right hand, sir. Do you affirm that the testimony you shall give in the matter currently before this court shall be the truth under penalty of perjury?
Yes.
Thank you, sir. You may lower your hand. Please state and spell for the record your full legal name.
Larry Lamont Walker, LARRY, LAMONTWALKER.
Thank you, sir. Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there a medication that you normally take that you have not been given today?
No, ma'am.
How old are you, sir?
45.
What is the highest level of education that you have completed?
12th grade.
And did you receive your GED or diploma?
Yes, I did.
Excellent. Are you therefore able to read, write, and understand the English language?
Yes, ma'am.
Ms. Rios, on behalf of your client, do you waive formal reading of the indictment?
Yes.
Sir, do you understand that you are currently charged with the following offenses? 1 count of aggravated battery and 1 count of cruelty to children in the first degree.
Yes.
Have you had an opportunity to review or discuss with your attorney the rights that you are giving up by entering a plea of guilty today?
Yes.
Have you had enough time to speak with your lawyer, Ms. Rios, about all the facts and circumstances known to you regarding the charges in the indictment, including any potential defenses?
Yes.
You need more time to discuss the case with Ms. Rios.
No, ma'am.
Are you satisfied with her services?
Yes.
Ms. Rios, on behalf of your client and for the purposes of this plea, do you waive any and all defects in the indictment, including any with respect to his name?
Yes.
Mr. Walker, have you been arrested on these charges?
Yes, I have.
Ms. Rios, the state is unaware of any outstanding warrants related to these charges. Do you know of any?
No.
Sir, has your attorney advised you of the minimum and maximum sentence for each charge you are pleading to?
Yes.
For the record, the sentence range for aggravated battery is 1 year to 20 years. The sentence range for cruelty to children in the first is 5 years to 20 years. So we would have to change it to cruelty in a second.
Okay.
So I'll go with that. Just, the state is going to withdraw for the purposes of this plea, its recidivist notice, but I do want to make you aware that if you are sentenced as a recidivist under OCGA section 17-10-7B or C, you will serve the entire prison portion of that sentence imposed without the possibility of parole, and that is true regardless of any advice by your attorney or anyone else. Do you understand, sir, that this is a negotiated plea of guilty, which means that the state and your attorney will make a sentence recommendation to the court, but the court does not have to accept that recommendation. The court could sentence you to the maximum on each charge and can run those sentences consecutively or one after the other.
Yes.
For the record, Your Honor, Ms. Rios and I have discussed the case. The state will withdraw the recidivist notice for this purpose today. And we would like to recommend to Your Honor a sentence of a total of 8 years with 2 years to serve. The conditions on the 8 years would just be that Mr. Walker take and complete an anger management class.
all right.
Mr. Walker, having heard the terms of the recommendation, do you wish to proceed with this plea?
Yes.
Do you understand, sir, that if you ever receive another conviction in the future, not saying that you will, but if you do, this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including the federal courts?
Yes.
Are you on probation or parole?
No, ma'am.
Do you understand, sir, that neither the court, your attorney, nor the district attorney's office has anything to do with parole, the Department of Corrections, or Board of Pardons and Paroles, and no one can guarantee parole no matter what anyone has told you?
Yes.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Are you a U.S. citizen?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, and or your right to receive, possess, or transport a firearm.
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yes.
I'm not going to go over the individual rights that you were waiving by entering the plea of guilty. Do you understand that you do have the right to plead not guilty?
Yes.
Do you understand that if you plead not guilty, this matter could proceed to trial?
Yes.
Do you understand that by entering a plea of guilty, you waive any and all defenses?
Yes.
And that would also include any mental health defenses?
Yes.
Do you understand that by pleading guilty, you are giving up each of the following rights? Do you understand that you are giving up the right to trial by jury,
Yes.
as well as the right to remain silent and not incriminate yourself,
Yes.
as well as the right to confront witnesses against you,
Yes.
as well as the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case,
Yes.
as well as the right to the presumption of innocence,
Yes.
as well as the right to testify on your own behalf and to present other evidence,
Yes.
as well as the right to subpoena witnesses and compel the production of evidence,
Yes.
as well as the right to have the charges against you proved by the state beyond a reasonable doubt.
Yes.
And finally, you understand that you are also giving up the right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Are you asking for any special treatment or special plea types for this one?
Return.
Huh?
You said something about return.
Right time.
So you gotta get my fares.
You're what? Oh, that's after. That's
Oh,
current.
okay.
No,
I'm sorry.
he did Alfred plea. Yeah.
Okay. Are you pleading guilty, sir, because you have decided that it is in your best interest to do so?
Yes.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes.
Are you asking the court to accept your plea as guilty under offer?
Yes.
As to indictment number 25 SC 007409, how do you plead to the charge of aggravated battery?
Guilty.
How do you plead to the charge of cruelty to children in the second?
Guilty.
And just for clarification, the state is reducing count number 2 to cruelty to children in the second to fall in line with the recommendation, Your Honor.
And cruelty to children in the second is what range?
That would, the minimum, Your Honor, is a year on cruelty to children. Second, I believe the maximum is 20 as well.
Okay, so it's the 5 that got in the way of the 2.
Yes, Judge.
Okay.
Okay, is this offered plea freely and voluntarily given with full knowledge of the charges against you? Do you understand that you do not have the right to appeal directly from your guilty plea? But if you believe there is some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal. The discretionary appeal procedure is outlined in OCGA section 5-6-35.
Yes.
Do you understand that you have from today until, well, no, I'll let the judge give you more information about what happens with your plea. Finally, let's go over a couple more things. You understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea.
Yes.
Do you understand that the appeals and filings that we have just discussed must be filed by your attorney unless you are representing yourself?
Yes.
Do you understand that unless your attorney is substituted or permitted to withdraw, your current attorney will represent you until either the end of the current term of court or 30 days from today's date, whichever is later?
Yes.
Thank you, sir. That concludes the questions and information I have for you. Your Honor, just to briefly summarize the facts of this case, which we did go over once before. The incident date is in October of
24.
24, thank you. And the victim in this case is Jeremiah Smith. He is the son of Mr. Walker. Jeremiah reported to school that morning. He had noticeable marks and welts on his arms. Based on that, his teacher sent him to the school counselor. The school counselor and the school social worker summoned EMS and Atlanta police to the scene. Police officers talked with the counselor and the social worker. Once a detective from APD arrived, Detective Franklin, then they spoke with the child, and crime scene came and photographed the marks on Jeremiah's body. A forensic interview was then scheduled. During that forensic interview, Jeremiah did disclose that it was his father that caused the welts by whipping him with an extension cord as punishment. As far as Mr. Walker's criminal history, I know that pretrial may go into that a little bit more, but for the purposes of this plea, the state will be withdrawing the recidivist notice. Additionally, it was based on Ms. Rios's advocacy for her client that the state agreed to come back and try this again.
Okay. We talked about this a little bit before, and I'll get more information from pretrial in just a moment, but one of Mr. Walker's convictions is for a child sex offense.
Yes.
Is he required to register, or that sentence is done so he doesn't need to register? I was trying to figure out, we were originally going to be here to talk about bond conditions and being around his kids, which he wasn't supposed to under the bond. And then I remembered, well, I didn't remember. As I was looking at the conviction, I wanted to understand whether he could be around kids regardless of bond because of registration requirements.
So my understanding, based on having looked at several different resources along with my supervisor, my understanding is that Mr. Walker is still currently registered, and regarding any living with children, so the requirements of the actual sex offender registry don't really speak to whether or not he can live with children. That, my understanding was, actually would be in the terms of his probation.
You're right.
However, his probation, I believe, is over.
Okay, so he would then be limited only by the registration requirements, which don't say, here's who can be in your household. They say your household can't be too close to a park, a pool, a church, a school, all that kind of stuff.
Yes.
And if he's registering, then someone has figured out, sheriff or someone, that that address complies with all the registry requirements.
Yes, sir.
Okay, that makes sense. Thank you. How many cycles does Mr. Walker have? Okay, and felony convictions? By your count. Okay. And Ms. Simpson, do you have Mr. Walker on active probation?
The case that you referred to is actually his last case that ended in 2024.
Okay. It must have been sentenced later because I have an 08 drugs and gun conviction. That's just, you're saying that ended longer ago, or the 05, the molestation case had a longer term of probation?
I believe that is correct, Judge. I'm verifying.
Okay, but either way, he's not on probation now, so we don't need to worry about closing something out there. Okay, Ms. Rios?
Thanks, Your Honor. Mr. Walker is 45 years old. He has 7 children. He has a family, his fiance, his children, and his mom, I believe, are here in support of him today. The letters that I gave you were from his mom because she's in fiance in case they're too emotional to talk. And a manager, I think, promoted him from one location to the Bojangles shift manager, which he's working now. And what?
And my kids also work for it at the same time.
And he just wanted me to let you know he also got his kids' jobs at the same company. I'm asking for you to go along with the plea as negotiated. I know Mr. Walker is going to want to talk a little bit, but I know he talked last time, and you probably remember, but I believe this is an appropriate sentence that me and the state have come to in this case, so I just had to accept the condition, the plea. And I've talked to Mr. Walker a lot about the situation. He's come to my office. I've talked to the mom, I've talked to the child, and it seemed to be a more complicated situation. I really not sure. But with the child, when I spoke with him, had a different story when we spoke with the forensic interview.
When you say the child, you're referring to Jeremiah, because there's 7 kids in the
Yes.
mix. You're talking about Jeremiah.
I spoke with Jeremiah. And from my understanding from talking to his family and the letters that he wants to do good, I know he had a history, but he was trying to do good and take care of his kids, and he wants to be out to be able to do that. And he understood that going to trial, there's a possibility that he wouldn't be able to be in his kid's life at all, depending on the outcome.
Right. Okay. I have read the letter from Ms. Walker, so mother of Mr. Walker. There's a letter from Ms. Simmons, and I'm not quite sure. It refers to you as a father figure, but you're not the biological father. Okay, so someone who's been important in your life and you've been important in hers. And then there's the letter from Corey, who I guess is the employer.
Yes, sir.
Great. Okay. They all had good things to say. Do you have anyone other than Mr. Walker, who I'll hear from in just a moment, who wants to say anything?
I don't believe
Yes.
so. Does anyone want to speak now? I guess the children want to talk.
Okay. If you think that it's up to you. You are managing things for Mr. Walker.
I don't think, maybe just a bit. Oh.
All right. Good afternoon.
Good afternoon,
You are
Anthony
Anthony. Your last name?
Smith.
Hey, Anthony Smith. What do you want to share with me?
I want to share that my father, he's the type of man that we need. You know, like he wants his kids, you know, to grow up to be someone. He don't want us to be out there getting in trouble and whatever. He wants everyone to follow their own path. Like he tells us every single day, you get up, go follow your dream, because you never know what happened.
How old are you?
17,
And are you in school now?
as judge.
Where are you in school?
I go to Tri-Cities,
Okay, so junior, senior?
junior.
Junior. So almost done with your junior year?
Yes,
Good for you. Do you do any extracurriculars there, sports or band
I
or?
play football.
Okay. And what are your plans when you graduate?
I was planning on going to the military,
A particular branch?
the Navy.
The Navy. Why the Navy?
The Navy because I feel like I want to, even though each branch go travel the world, I feel like I want to go to the Navy because I feel like that's my path right there. You know?
Okay. Where do you fall on the 7 kids? Youngest, oldest?
I'm the oldest,
You're the oldest.
the second oldest.
Second oldest. Okay. And the oldest is how much older than you?
She's 23, I think.
Done with school.
Mm-hmm.
Got it. Does she stay at home with you all or is she on her own?
She's on her own.
Is she local? Do you get to see her some or is she in
Yeah, we see her
California?
time to time.
Okay. All right. So there are 5 who are younger than you in the house.
Yes.
Got it. All right. Well, I appreciate you sharing that. And I understand that your father is more than just what happened here. It's a complicated situation. I trust that you will be very supportive of Jeremiah as everyone works through this. Okay. Anything else?
No, Judge.
No? I appreciate you being here. Good luck with the rest of your school year.
Thank you.
All right. Did Tri-Cities have a good football team?
Yes, I do.
They do? Okay. Good.
Judge, I did want to point out that, since Jeremiah is the listed victim, he does have the right to speak should he wish to. And I do believe he is in the court.
Okay, I'd leave that to you. So you can consult with it's a complicated dynamic right now.
It is complicated, so that's why I want to express it in open court.
Yep.
If Jeremiah wishes to speak, he certainly can.
But he doesn't have to at all.
Okay.
All right, so stop for a second. I need Mr. Walker and Jeremiah not to be right next to each other. So why don't you take a seat, Mr. Walker? Middle seat at that table right there. Middle seat. And I'm gonna have Jeremiah stand near Ms. Willingham right here at the corner. Great. Hey, Jeremiah. How are you? Tell me how old you are. 11 years old. So 5th grade? 6th grade. Wow, you're ahead of yourself. Where are you in school? Do you like it?
Yes.
What's your favorite subject?
Math.
What? Math and reading. What's your least favorite subject?
Science.
Why?
Because I get to learn about different things.
Okay. Well, Jeremiah, was there something you wanted to tell me? You don't have to say anything at all. I think it was good to meet you, but if there's something you want to share, you can. But you could just go back and sit down and be with your mom.
My dad.
Okay, you can, but talk to me about him, okay?
He's like a great dad, and he always got me every day. And he always does me.
You can stand for me and read.
Hey, Jeremiah, you don't have to do any more talking, okay? You want to go sit with mom, or do you want to talk some more?
Okay.
Okay. I appreciate you coming up here. Ms. Rios, anything else?
No, Your Honor.
Okay. Mr. Walker, just like Jeremiah had a right to be heard, you have one too. You don't have to say anything more than you did last time. I know we spoke before and you told me all about the dogs and every other possible explanation for what happened. But I'm happy to hear more from you if there's anything you want to add.
Yes, Your Honor. Your Honor, I'm talking to you from a father point of view. I lived all the mistakes I made in my life. That's my lifeline. My kids, my wife, my mom. My mom also fighting to be there for my sister, who's also she's.
I heard she's not well. I'm sorry.
Yeah, she's trying to do better. So, but they my lifeline. You know, I don't think I teach my kids not to be part of the statistics, not to be. You know, just grow up, you know, enjoy your life, but stay away from the trouble. Like, I mean, it's really much, I'm not no perfect father. It's challenging. They gave me something that I never had, and that's to be in the house with a whole bunch of children in their own different way. They're unique in their own different way. And I'm gonna miss that. I'm sorry.
You don't need to apologize. This is difficult.
I know mistreatment one of my children. That's beyond ugly. I treat my kids to be a survivor, be a supporter, be just a good young lady, a good young man at the end of the day. That's all I can say.
Okay. Well, Mr. Walker, it's clear to me that in many ways you care a great deal about your family. You'll be back with them. This is nothing about this is forever. But I will tell you, in looking at the pictures of Jeremiah, someone did something to him. It wasn't dogs. And even if it was dogs, then parents weren't taking good care if he was exposed to a risk like that. You're the one stepping up. Whether it was an older sibling or his mom or an uncle, that young man was physically mistreated around the time those pictures were taken. And when he was in a safe space, he described what happened to him. Families can be complicated. You're going to have time to reflect on how to handle things differently, because it's not going to get simpler as your kids get older and learn how to give you their thoughts on things. And when they're little, you're the greatest thing in their life. When they get older, you're a set of car keys and some dinner money, and otherwise you're just sort of an obstacle to them going out and having fun. And you'll need to navigate that in a way where you keep your hands to yourself. It won't be easy, but you'll be back with your family. There just needs to be this time where everyone can reflect on what happened and make sure nothing like that happens again. I think you all wanted to talk about a reporting date. I don't know if you talked with Ms. Williams about that.
I have not. We were just gonna be asking for at least 2 weeks for him to get his affairs ready, together, maybe help with the money a little bit more, because the mother will be left to fend for herself and the children. And I think 2 weeks will give him a little bit better cushion with that.
Okay. Ms. Williams, do you have any thoughts about Mr. Walker? I know I haven't gone through with the sentencing yet, but it's a negotiated plea now that's much more in line with the level of concern I had about this situation. So assuming I follow the negotiations, what are your thoughts about a turn-in date?
Your Honor, the state needs that in the hands of the court.
Okay. Have you received any assurances from Ms. Rios, more than assurances, some kind of evidence as to where Mr. Walker is staying in these days leading up to today, and then ultimately a turn-in date if he doesn't go into custody now?
Your Honor, I looked at the docket and I didn't see a change of address, so that's where, that's basically where I would look first.
Okay.
I didn't see it.
All right. Ms. Rios, what is going on with Mr. Walker's living situation?
He's living with his sister. I did not do a change of address, but I can. But he is staying with his sister.
We don't need to do that now. I mean, there's not a ton of time we're talking about here. The sister who's not well?
Yes.
Okay. And where does she live? I don't need street address, but is she in
Lithonia?
In Lithonia?
Yes, sir.
Okay. Okay. And your family home is on Deerwood or on Etheridge Drive? Or neither?
Neither. It's in Hapeville.
In Hapeville.
Yes,
Okay. So we got not even the right address. Oh, but I think we already went through this before. Let me look. Yeah, you did a change of address form, Oak Drive in Hapeville?
Yes, sir.
Okay. I don't know why that didn't go through. That's not on you, but you're in Lithonia. All right. Mr. Walker, as I did before, I find there's a factual basis for your plea, in that your plea is knowing and voluntary. Knowing meaning you've understood what we discussed, and voluntary meaning after much thought, prayer, consultation, you've decided this is the right way forward for you. Do you agree with that?
Yes, sir.
Okay. Ms. Williams, can someone in my office sign the indictment for you?
Yes, thank you.
Ms. Rios? And Mr. Walker, is it okay if we electronically sign your name to the indictment indicating your guilty plea?
Yes.
All right. The recidivist notice has been waived. We talked about registry. So, Mr. Walker, having reviewed these letters, having met Jeremiah and your other son, I will follow the negotiated resolution and sentence you on count 1 to 8 years to serve 2 with the balance on probation. Count 2 is the same sentence. They'll run concurrently with each other. You'll get credit for the time you already served, which is a month. And your special condition of probation, when you are out, is to enter into and complete a family violence intervention program, which is going to give you additional coping skills to manage the large family that you will still have when you are reunited with them. Everyone will be a little bit older, but they're still your family. You'll need to enroll in that course within the first 3 months of probation. It takes a little while to finish, but you got to get it started within the first 3 months of probation.
Gotcha.
In terms of a turn-in date, I am open to that. You need to understand two things about that. We will have you turn yourself in on May 11th. So it's not, well, that's not really 2 weeks, but that's going to be complicated. I need to make it May 11th. So it's a little bit of time. It's not quite as much time as Ms. Rios asked for. You need to be here at 9 a.m. on May 11th. If you
Or the jail.
here, oh, 8D, come here. Don't bring lots of stuff.
No.
That may be a very meaningful set of dog tags you have.
No.
No. It's okay. It's okay. I'm sorry for
That's
that.
okay. Emotions are running. You don't need to apologize. It means your mom cares. Don't bring something like that only because I don't want you to lose it. And I don't know what you get back when you turn yourself in.
Yes, sir.
Be here by 9. If you're running late, you need to let Ms. Rios know so she can contact my office. If you are not here at 9 and we get to 9:15, 9:20, and Ms. Rios says, I don't know where Mr. Walker is, just understand that your sentence will be 10 to serve 5.
Okay.
Okay? So it's exactly what your lawyer negotiated if I see you by 9 a.m. on Monday, the 11th. So not next Monday, the Monday after. But if you're not here within 15, 20 minutes, Ms. Rios has no idea where you are, she can't reach you, then I will sign a sentence sheet, but it's 10 serve 5.
Okay.
You're not going to be hard to find because you're not going to want to be away from your family. And then you will have bought yourself 3 more years. So the message there is be on time. If you are driving here and you get a flat tire, you blow up Ms. Rios's phone. Say, hey, I'm coming. Look, here's a picture of my tire. It's flat, and we'll work with you. But silence, disappearance is the wrong choice.
It's
Okay.
not a choice.
All right.
Thank you,
Mr. Walker, I hope that when you reunite with your family, everyone is in a better space. And it is important that no one in this room think that Jeremiah did anything wrong other than be a little guy who wasn't treated the right way. Okay?
Yes, sir.
All right.
Good kid.
Thank you.
Thank you, Yon.
May I
Yeah, 9 o'clock.
text me if it'll happen?
Don't be late.
I'll be here after probably child.
Okay.
I mean. Of course, that's the permanent.
Oh, yeah, he's sorry. Are we gonna do that? Okay.
Yeah, technically, I didn't know certain. I wonder if I should see it. Okay, so he can't really do this, so now it's sorry. They'll have to have a third party, but they're not legitimized right now, so, okay. Well, I have to get to the sign this part. I have to bring them forward to the documents.
Give me 1 second and we'll turn to the next.
Rio stepped out.
Oh, well then we need,
It's
it's not your fault.
It is, well, because I gave her the permanent protective order for Mr. McGlone. So.
Okay, it's your fault.
Yeah, so.
I thought she stepped out with the family.
No.
Oh.
I just want to make sure she's being confused with the second one. What does it? Oh, okay. Right, so it wasn't the first. Right. This email was sent. Right, okay. Just.
We have to start calling. Oh my God.
Has it automatically switched already?
But it
Oh,
will.
okay, yeah, I haven't clicked it yet. I don't want to. Wait, you'll go back though.
It will.
Okay, so then I'll test it. Go
It
back.
doesn't scroll. It doesn't scroll. I don't know that time. Right, it's too many things.
I'm like, we all gonna need to do it. I'm about to train. Wait, so we getting this new one now and then we gonna have to learn another new one?
Yes. Exactly. That's precisely, yes.
See, that's probably what we want to learn.
Mr. McClone?
Yes, I didn't know if you. Yeah, but.
Okay. Do you know who in your office now handles petitions to come off the registry? Mr. Getachew Smith used to do that. So defendant X had to register, but he's done with his sentence. It's been 5 years. Statutorily, you can petition to come off, and Getachew Smith would handle those.
Just the regular SAG will do it. Well, it depends. If it is a registry for a shopping place, then.
Yeah, it was some crime out of Illinois from a long time ago, and the guy's done with it. I don't remember it. It's not your case originally, but he lives here now. And basically, you guys are in default. This guy filed the lawsuit. It's a civil suit. He served your office and no one answered. And so he's saying, I should get to deregister as a matter of default, which is not going to happen. I'm going to have a hearing. I need to know who to drag from your office in. And I've made a couple other inquiries, but if you don't mind just reaching out, like, who should McBurney contact?
Probably gonna be, Judge, it's probably gonna be Caitlin McGillicuddy or Siri Patel.
That's my thought.
Depending on-
Which, that's why I said.
It just depends on what his underlying offense was.
If
All
it's
right.
a child-based offense, it would be Caitlin McGillicuddy. If it is an adult-based offense, it would be Siri.
Okay, and it's not someone in the appellate section, because Getachew Smith was an appellate guy, and
No, when I see, because I've seen a hearing for that, but it was in Judge Maxey's courtroom, and Ms. Nix actually handled it, but it was
Okay.
an adult.
Okay. Well, I can find that out. It listed whatever it was in Illinois, and we'll figure it out. Okay, Mr. McGlone, I'm sorry. I didn't mean to take up your time with that. I was letting Ms. Willingham get ready, and then I was interrupting her getting ready. So let's get on the record in your cases. Mr. McGlone, you have 25 SC 005-805, a case in which you're charged with aggravated assault, a couple other offenses. And then 25 SC 006-410, a case in which you're charged with aggravated stalking. Ms. Rios represents you in both those cases, and she's standing right next to you. Ms. Willingham is going to handle both cases, I think, for the state. She's going to put you under oath in a moment, ask you questions about you and your case and your rights. You need to answer those questions truthfully. You also need to let me or Ms. Rios know if you have questions while we're going through this. Will you do that?
Yes.
Okay. You ready to go?
Yes, sir.
All right, Ms. Willingham.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Please, I'm sorry, you can put your hand down. Please state your true, correct, and legal name.
Cody Mauricio McGlone.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
How old are you and how far have you gone in school?
34 high school diploma.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial?
Yes.
Have you had enough time to speak with your lawyer about all of the facts and circumstances known to you regarding the charges in these indictments, including any potential defenses?
Yes.
Do you need more time to discuss the case with your attorney?
No.
Are you satisfied with her services?
Yes.
Counsel, are you satisfied your client has a full understanding of this proceeding?
Yes.
Have you reviewed the indictments with your client?
Yes.
Do you waive formal reading of the indictments?
Yes.
Has your client been arrested on these charges?
Yes.
The state is unaware of any outstanding
No.
warrants
You been
related to these
arrested?
charges.
How did you get here?
That's what that's the question. I was never arrested on aggravated stalking or aggravated assault.
You
All right, I'll look it up in just a sec.
You want me to keep going, Judge?
Yes.
Okay.
We asked that question more so just to make sure there aren't warrants out there, not to say, haha, this case never happened.
Well, originally had an FTA for the aggravated assault. The stalking got added on because I had gotten into another incident with the same victim.
That's where aggravated stalking comes from.
Yeah.
Okay.
The state is unaware of any outstanding warrants related to these charges. Do you or your client know of any outstanding warrants related to these charges?
No.
Mr. McGlone, do you understand you are entering a plea of guilty to the following offenses? As to indictment ending in 805, aggravated assault, family violence, criminal damage to property in the second degree, and battery, family violence, first offense.
Yes.
And as to indictment ending in 6410, aggravated stalking.
Yes.
Has your attorney advised you of the minimum and maximum sentence for each charge you are pleading to?
Yes.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court an overall sentence of 5 years to serve 1 year? As to indictment ending in 805, count 1, 5 years to serve 1 year. Count 2, 5 years to serve 1 year concurrent to count 1. Count 3, serve 12 months concurrent to count 1. And indictments ending in 410 will run concurrent with indictment ending in 805. And the sentence for that will be 5 years to serve 1 year. The state would be recommending that you have no contact with the victim, referenced by the permanent protective order you've signed, that you would be required to complete family violence intervention program, complete 60 hours of community service, seek and maintain gainful employment.
Can you repeat the conditions one more time? I got the 5-serve-1.
Yes. Permanent no contact as referenced by the permanent no contact order.
Yep,
Complete family violence intervention program.
yep.
Complete 60 hours of community service.
Hmm.
And seek and maintain gainful employment.
Okay, thank you.
And Your Honor, the state would note for the record that we do understand that the parties share children in common. However, it is my understanding as of today, those children have not been legitimized. Ms. Williams will be seeking that. She does understand they will ultimately need a third party, but she was very adamant that she does want this permanent no contact order put in place.
Okay,
So I just wanted to, because I recognize that may create some kind of an issue, but my understanding is their communication can still be through a attorney.
Right.
and we would not have an issue with them appearing in court at the same time, obviously, but
okay. When you say they haven't been legitimized, I think it's legitimated, but I'm learning this. Meaning, they are very clearly Ms. Williams's children. She birthed them. She may not be disputing that Mr. McGlone is the father, but legally, he's not the father yet. That may happen, in which case they would need to go to court to figure out shared custody or however that's going to work. But as of this moment, Mr. McGlone does not have a legal claim to spend time with the kids.
correct. And it is my understanding that she will be seeking that.
Or she will want the,
Yes.
okay,
Because that has
legitimation.
to happen for child support purposes as well.
Ah,
So
okay.
I do know that she will be seeking that, but that's why I wanted to make sure that that is also noted on the record. Were those the conditions explained to you?
Yes.
And are you aware that the court does not have to accept that recommendation and the court can sentence you to the maximum sentence on each charge and can run those sentences consecutively or one after the other?
Yes.
Do you understand that if you do not accept the court sentence, have we had final plea? Have we had final plea?
No.
No.
Do you understand that if you do not accept the court sentence, you may withdraw your plea? You may withdraw your plea today?
Yes.
Okay.
This is a negotiated plea.
It is.
Right. So if I sentence you to more, if I sentence you 5-2, you'll have a chance to talk with Ms. Rios about it. And if you would rather go to trial on these cases, you can walk away from the plea. If I go along with the plea or go below it, you're locked into it. But if I'd say 5-2, 10-5, anything like that, first you'll get a chance to talk about it. And then if you say, let's go to trial instead, you have the absolute right to walk back that plea and no one will know what ever happened. Meaning the jury would never be told that. And we'll just get you into court someday to do a trial. Okay?
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to the revocation of the balance of this sentence?
Yes.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts?
Yes.
Do you further understand, because there are family violence convictions, that you will not be allowed to have a firearm, and if you are found in possession of a firearm, you could be charged federally?
Yes.
Are you on probation or parole for anything, anywhere?
No.
Are you a United States citizen?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to the charges of aggravated assault, family violence, criminal damage to property in the second degree, and battery family violence first offense in indictment 25 SC 005805?
Guilty.
And how do you plead to the charge of aggravated stalking in indictment 25 SC 006410?
Guilty.
And I'm gonna go back. Do you understand that you are not allowed to possess or use a firearm while on probation, even if sentenced pursuant to the First Offender Act?
Yes.
Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes.
Have you ever pled guilty or nolo or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No.
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No.
Has your lawyer explained the First Offender Act to you?
Yes.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for each charge in this indictment?
Yes.
And Your Honor, for the record, the state would be deferring to the court as to whether the defendant can use first offender on both charges. That was the discussion between the state and the defense on that.
Okay.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
You do not have a right to appeal directly from your guilty plea, but if you believe there is some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal. The discretionary appeal procedure is outlined in OCGA 5-6-35 and must be completed within 30 days of today.
Yes.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Your Honor, as to indictment ending in 805, if this case were to proceed to trial, the state would expect to show on June 17, 2024, at approximately 1800 hours, Officer Jones was dispatched to the incident location in South Fulton, Georgia, Fulton County, in response to an assault call. Jones met with the victim, Miss Williams, who stated that her children's father, identified as Mr. McGlone, came to her home unannounced and assaulted her and damaged her vehicle. He entered her home while Williams was downstairs working and continued to verbally argue with Williams. Williams stated that McGlone snatched her work laptop out of her hand and broke it in half. She stated that McGlone began to hit her in the head, face, and ears multiple times. Williams stated she ran upstairs, grabbed her gun, but McGlone was able to wrestle the gun away from her. Williams then ran outside and called 911 with McGlone following her outside. McGlone went over to Williams' vehicle and stabbed her 2 passenger side tires with a knife. She stated that McGlone got into his vehicle and tried to hit her and fled the scene. Jones observed red bruising on the left side of Williams' face. She also saw the black laptop broken in half. Jones reviewed surveillance or ring camera footage of a black male subject exiting the residence, stabbed both of the tires of a silver Lexus. The video showed the same black subject get into a gold sedan, back out of the driveway, and drive towards a female who was standing slightly in the road. McGlone has had 2 open misdemeanor cases involving the same victim, Miss Williams, pending. And as to indictment ending in 6410. The state would expect to show. The state would expect to show that on September 7th, 2024, Officer Paul responded to 6743 Marywood Drive in reference to damage to property. Upon arrival, they met with Ms. Williams, who stated that the father of her children, Mr. McGlone, assaulted her in Clayton County at a party, then broke into her house. And Your Honor, at the time of that contact, Mr. McGlone had an active bond order that was issued on, I'm sorry, I'm thinking.
Was it a bond from the 805 case or was it one of the
No.
Judge Morrison state court cases?
Yes, it was the state court case, Your Honor, and that was issued on. It looks like it was issued on June 21st of 2021. And it was still in place at the time of this incident, and it had a no contact with Tiana Williams. And it also listed in a stay away from that incident location, the defendant was to have no weapons, drugs, or alcohol. And Your Honor, I have talked to Ms. Williams. Initially, when her and I first spoke, I explained to her that I would actually probably be asking for more time. The defendant had an open state court case, and there were literally 3 cases pending at the time of this. We had 3 cases pending at the time we had plea and arraignment in this courtroom. And ultimately, in our last communication, although she did want him to spend more time in custody, she didn't at the same time, because although she wants no communication with him, she does feel that she needs him to be out and be able to get a job, because she wants to be able to seek child support, and she does want her children to be able to have a relationship with him, which is why she does plan to go through that process with the family court. And she kind of went back and forth about it for a while, but that was our last conversation. And when I followed up with her again, she still feels the same way, that although she does recognize that she agreed I probably could get more time, but she would prefer that he not be in custody much longer, so that she's able to actually start to pursue some things on the custody side.
Okay. How many kids do they have together?
I believe she told me 2, but I'm actually going to lean to Mr. McGlone to
All right,
confirm
we'll
that.
find out from the source. We'll get to you in just a second.
Okay.
All right, so you've received input from Ms. Williams. She's torn. Part of her would be fine if he went away for a long time, but she loves her kids and wants him to support them, but also wants them to have their father in their life. Okay, well, I get that. Thank you. Any felony convictions at this point for Mr. McGlone? No. All right. Ms. Rios?
Yes, Your Honor. Mr. McGlone is 34 years old. He has 2 children, ages 11 and 5, and they're both girls. And before he was arrested, he was working as a forklift driver. He is also has his license and certified, and he plans to be able to.
His what license?
His forklift license.
Oh, okay. He is a forklift driver with a valid license.
Yes, Your Honor.
Okay.
Prior to that, he was also a manager at a warehouse and has had several logistic jobs. So when he is out, he is going to be able to work.
Yep.
A part of the reason why I'm asking for both cases to be treated as a first offender. I do understand his history. I understand that he had misdemeanor cases. This all it's not like he has these situations and then a whole bunch of other stuff. It's that all is connected to his toxic relationship with the mother of his child. And I know one of her concerns is him being able to work, and he has a better chance of getting a better job without having a felony conviction, and then he can better provide for the children. So I think that serves everyone if he's able to do that. And if he has an issue again and contacts her, you can revoke him on first and resentence him. So he has a good incentive to not to have any other issues with her. And I believe most of those cases were about 2 years ago. So it hasn't been nothing as of very recent. Let me double check, but I believe nothing as of very recent. This is all from stuff from 2024 is my understanding. So I ask that you accept the plea as negotiated and let both cases be under the First Offender Act.
Okay. Mr. McGlone, do you have any questions for me about anything we've discussed?
No.
Do you have anything you want to add to what Ms. Rios said?
I want to basically just say it was a toxic situation that I moved on from.
Okay.
I just want to get back to the children and be a father to them.
All right. What are their names?
Kendall and Morgan.
Kendall is the 11-year-old.
Kendall is the 5-year-old.
Morgan's the 11-year-old.
11-year-old.
Okay.
Yes, sir.
Do they come visit you at all right now in custody?
No.
No. Okay. Do you have kids in any other situation, or this is it? Those are your girls?
Yes.
All right. You understand that going forward, you will be able to have them to some extent in your life, but you won't be dealing directly with Ms. Williams for that to happen.
I understand.
She controls the cards right now,
Yes.
but if there is a legitimation so that you're shown legally to be their father, then you two, Ms. Williams and you, can sort out how custody will be shared. You certainly will have child support obligations. There'll be a judge in the mix and ideally some neutral representative, because you aren't to have contact with Ms. Williams. You don't call her to say, when can I see Kendall? I'd like to do this. There'll need to be some third party who's designated, and the court can help you with that, or a lawyer can help you with that, whether it's, I'm making this up, her aunt or your sister or whomever. And that's the person who would do it. But even though you could be reaching out for something as innocuous as, hey, they don't need diapers, they're older than that, but I'm helping out with X. You can't reach out to her that way.
How about reaching out? Because the oldest girl, she has a cell phone. Last year or so, I've been communicating straight through her. I haven't even called.
Your daughters are not covered by the no contact. Okay. But what you cannot do is use your daughter as a conduit. Hey, tell your mom that I want to see you on Sunday. Okay. Because then your daughter goes in the room and says, Dad says, and the moment she says that, that's you communicating to your mom, to Ms. Williams, her mom. And again, you may be very well intentioned, like, hey, just check with your mom if I can get you this weekend. That's unless the court or you and Ms. Williams, but you can't, there's no way you can interact with her. So someone, a lawyer, a neutral, a judge, is going to say, here's the intermediary. They rarely designate it as the kid, unless the kid is biologically your kid, but is 22 years old. Gotcha. But you don't need to go through her mom to get in touch with your 22-year-old before even an 11-year-old, even though she's got her own phone. Nothing wrong with you contacting her where you will trip up. And if Ms. Williams is feeling a certain way about you, she could not incorrectly say, hey, he violated this. And that's your quickest way back to jail, is Ms. Williams being able to demonstrate to the state, hey, he had contact with me. He called me directly, or he gets my daughter to put it on FaceTime, and then she holds the phone up and, oh my gosh, there's his face. That cannot happen. Well, let me just put it this way. If it does happen and Ms. Williams reports it, that's curtains. That's bad news for you. So feel free to contact your daughter, but don't, even as unintentional, like, hey, tell your mom Merry Christmas. None of that. And you guys will figure out through the court system who that intermediary is for arranging visits, contact, that kind of stuff.
Okay.
All right. Well, Mr. McGlone, I find there's a factual bit. Did you have other questions?
Yes, about the plea.
Okay.
The 5-1, is it prison time? But I would like it to be county time.
So here's how that works. You will get credit for the time you've been in, and you are getting awfully close to 6 months of credit. Generally, but I'm not the sheriff and I do not control the sheriff. If what remains is 6 months or less, they just say stay put because it's expensive to get you to Jackson.
Okay.
And by the time they do intake and figure out, hey, let's send McGlone to, time's up. Because you're parolable, and so they may look at you with only 6 months left on your sentence and say, let's let them out. And so why did you go all the way down to Jackson? I just can't guarantee that you're right at that edge.
Okay.
So is it possible that you stay local? It is.
Okay.
Am I promising that? I am not.
Okay. Thank you.
You're welcome. Other questions?
No, that's it.
Okay. Well, Mr. McGlone, I find there's a factual basis for both your pleas. It sounds like, and I'm sure there's another side to the story, but on that situation in June, you lost it and really took it out on poor Ms. Williams' belongings. And then what happened a few months later, you needed to be staying away and you didn't stay away. I'm glad no one got too badly hurt. Sounds like you did put your hands on Ms. Williams. One of the many reasons we're building these barriers is so that something like that doesn't happen again. So I do find there's a factual basis for both cases, and your pleas are knowing and voluntary in both cases. You've understood what we talked about, and you've decided on your own free will, that you want to enter pleas in both cases. Is that correct?
Yes.
I will accept both. Ms. Rios, can someone in my office sign both indictments for you?
Yes, Your Honor.
Ms. Willingham?
Yes, Your Honor.
And Mr. McGlone, can we electronically sign your name indicating your plea in both cases?
Yes.
All right. So in terms of first offender, given the fact that there are a couple misdemeanors out there that I've seen with Judge Morrison involving Ms. Williams as the victim again, I will give you first offender on one of the cases, but not both.
Okay.
I don't know if it's significant which one gets first offender, so you may want to talk with Ms. Rios. Do you want the ag stalking to be first offender or the ag assault? And the main benefit to you of first offender, since the other case isn't going to be first offender, is that one can be sealed up so that if an employer is checking your history to say, hey, can we hire this guy at this warehouse, they won't see that one at all.
Okay.
The other one, they'll see you got a conviction, but you're going to tell them that in advance because you'll put it on the form so you don't surprise them, and then they think you're not being candid. And I will give you first offender on whichever one you want.
Okay.
I think that's a smart call.
Yeah.
So I'm going to start with the other case because it's lower in number. In 25 SC 005-805, I'm sentencing you on counts 1 and 2 to 5 years to serve 1 year with a balance on probation. Count 3 is 12 months to serve to run concurrently with those other 2 counts. So total sentence, 5 serve 1, exactly what you negotiated. You'll get credit for the time you've been in custody. Special condition number 1 is a permanent no contact with Ms. Williams. That goes on forever until you come back to me through Ms. Rios and you get it changed. And it could well be that Ms. Williams wants it to be changed, and I'd hear that through the prosecutor because she is okay meeting at McDonald's to exchange custody of the kids. And it's just easier for both of you if you two can do that. But until that condition is changed and this permanent protective order is modified, if Ms. Williams says, hey, meet me somewhere, that's a trap. And I don't mean to suggest she would trap you, but she may have forgotten about it or just say, hey, it's easier to do that. You need to protect yourself because you could show up and she just goes click and there's a picture of you within 5 feet of her, which is blowing everything up.
Yes.
And Judge,
You seem concerned about that.
Yes, the permanent no contact statutorily can actually only go on the aggravated stalking. It can be a no contact.
Okay. Great. That's a clarification. So there's a condition of no contact on your ag assault case. It's just not where this order goes, but the order is still there and you're going to need to comply with it. 2 other conditions. You're going to enter into and complete the Family Violence Intervention Program. You need to start that within the first 4 months of your probation. So when you get out, you get a little chance to get settled, but within the first 4 months, you got to enroll in that program. It's a series of classes. And you'll need to complete 60 hours of community service. Those you'll need to do within the first 8 months of probation. So we're front loading things, you get those out of the way, and then probation will be no sweat for you. In your other case, 25 SC 006410, I will sentence you as a first offender. So you understand the benefit. That means that it's not a conviction. You can have it sealed, and if you successfully complete your probation, it basically disappears.
Okay.
The risk of first offender is that if while you are under sentence in that case, you mess up and get arrested for something, in particular, anything to do with Ms. Williams, not only are you sideways with probation, but I could resentence you because you pled guilty all the way to the max. And you have a hearing, but you don't get a trial. So you could go from 5 to 1 to 10 to serve. If you're pretty sure you're going to have no trouble staying out of trouble, first offender makes a bunch of sense. Do you want to be sentenced as a first offender?
Yes.
Okay, I'll do that with the aggravated stalking case. Your sentence and the only count there is 5 to serve 1, balance probated. Again, you get credit for time you've served since that arrest. And 3 special conditions. 1, you will abide by the permanent contact order, no contact order. That's what I've just signed. You signed it as well.
Mhm.
That's the forever order. This lasts until it is set aside or vacated or something like that, which requires court action, not just Ms. Williams and you saying, hey, let's ignore that protective order. Condition 2, that Family Violence Intervention Program, again, enroll in it within the first 4 months, and then 60 hours community service. It's the same 60, it's not 120.
Okay.
And you got to knock those out within the first 8 months of your probation. Ms. Willingham, anything else in connection with Mr. McGlone?
Nothing from the state, Your Honor.
Okay, you don't sound so good.
I have to cough.
Okay. Ms. Rios, anything else?
No, Your Honor.
Mr. McGlone, any questions?
No. Thank
Okay,
you.
good luck with things.
Thank you.
Sorry, I was trying not to cough on your record.
It's all right. People cough when they have to cough.
Are you really sick? You sick?
She got a problem over it. I'm not contagious anymore.
So she says, y'all get taken down by William.
Which I don't ever do, but I actually was like registered in music. And that concludes my business savvy experience.
Yes, ma'am. How was the fire department?
It was good, and actually, both the fire department and, I had Detective Grandy here from APD. And both of them were like, oh, is this in McBurney's court? And I'm like, no, I'm sorry. But they were like, oh, I love him.
Alas, not much longer.
Judge, I do actually have a question, not about any case that's in here or anything, just kind of want to pick your brain about something. If a defendant has been sentenced in custody, part of their probation is no contact, but they're not actually on the probation part yet. Is there anything that can be done? I've had this issue with Judge McAfee before, and we couldn't quite figure out how you handle it outside of now during my pleas. I typically, if there's an in custody portion first, I typically will ask that the no contact run during the duration
Yeah.
of the sentence. Or if there is a permanent no contact, it usually covers it anyway.
Right. But oftentimes we don't think of it. We just say, hey, when you get out, I have had good success both with the sheriff and with the Department of Corrections in reaching out. Judge reaches out saying, hey, this inmate has been contacting, and so you need to shut off. DOC, they'll just shut off all communication privileges. You can't call anyone. That gets their attention. With jail, with Securus, they can say, well, we can block a number. What's the number you don't want this person to be able to call? Now they can get around it by saying, I'm going to use my fellow inmates But then when you get word of that, you bring it back to me and then we say, no securus at all. You just don't get to call anyone. And because they can regulate that. It is a privilege to be able to contact people, not a right. And in particular on the DOC side, they are fine saying, we're shutting it down. So that's my recommendation, is that you get with the judge. Obviously, you let the defense attorney know, but it's post-sentencing. So it's more, as long as there's evidence that it happened, the judge just reaches out to our contacts with GDC.
Okay, thank you.
You bet. So Wells?
Well, she's trying to figure out the new accusation situation.
Oh, right, we were gonna get a new number.
Yeah. We'll get into the right one. Yeah.
Okay. Did you see that again? Well, not that she can, wants to do it.
Oh, no, I don't know what to do because y'all should fire. So, what? Well, she's the defendant that I said that she needed.
I thought it was something she wanted.
Well, she fired me, so I don't know how we're going to time. But then I think she could be hired.
So when that happens, is he just going to another? No, she got me or she can hire, so we're gonna figure out which way.
Yeah.
Talk to her dad and she was, so that was the whole thing. I don't know, the uncle, he doesn't wanna go for it, can we do something else?
Yeah, so that's the cost we were doing, so.
What's her name? The other kids I had that we did a divergent situation where he got into a state program for like 6 months and then the case was dismissed, thought possible, he was black, he used to be like that. If she would work with the decision maker and get her inside.
I don't think.
I will be right back.
Yeah. But the only thing that is. Even that she is. This is distance. Now the answer, I think that's fine. That's all the pain still.
Oh, she definitely will. Which will show that she does, but I mean, I'll see if I can talk to her here.
I don't know if we could even sit through a trial, if she won't take it, and then the trial have to do some type of. I don't know how we get
I
it.
think the biggest thing is getting help for her. Yeah. I'm not trying to throw it.
Yeah.
Because I'm sure she can't follow up.
I'm gonna talk to her, I'm letting her cool down.
Sucks.
I think Xavier was on probation.
Yeah, we haven't had a probation hearing. Ms. Simpson agreed with the facts they're going to.
So I think he was on probation for.
He's what?
No, I'm just trying to see what he's on probation for. I think he was added some. Yeah, he's possession during.
She got the first person here to be your vote, so.
Two, what the issue is.
It was wrong.
The issue is your second position of firearm during is 10 years fireman.
Yeah, that's fine.
Yeah.
And the charge, it has to be charged as, I think it has to be, it's not decided that way.
No, I don't think so. I think if it's position of firearm during is your second or subsequent offense, then it's a 10-year. I mean, but I know what you're talking about. I don't think you're talking about. You doing the revenue of firearm on the position during 133. That's what we have both together. Yeah. It says upon a second or subsequent conviction of a person under this code, this person shall be punished by confinement for a period of 10 years. The second of any person which is imposed violating this code shall not be suspended by the court, probation or sentence imposed in Louisiana.
Do we have a accusation number yet?
No, Your Honor, I just sent an email about it, so I'm trying to, hopefully I'll hear back quickly.
So, this is for the case ending in 589?
Yes, Your Honor.
Ms. Rios, does Mr. Wells know what he's pleading to? We just don't have the number yet, or? Okay, because another approach would be to go forward with pleas in both cases, and we just refer to the new case as 26 SC unknown, something to that effect. He, as long as he knows what the charge is and whatnot, I feel like we could knock that out. I don't mind waiting a little bit longer. I just don't want to keep everyone here. When you reach out, are you calling your office or you're contacting someone in the clerk's office?
I'm contacting someone in the clerk's office.
Okay.
But I'm fine with going forward as long as Your Honor's fine with not having the new case number yet. Or the
Okay.
new accusation.
Right. What is the new allegation?
Cruelty to children in the setting.
Okay. And what is the clerk's office telling you, that just we don't have it yet, or?
Well, I dropped it off by hand,
Mm-hmm.
in the clerk's office at noon. So they have everything. They have my personal cell phone number in case I forgot something. I haven't gotten any notification that there's something wrong with the documentation I've dropped off. They may just be inundated today for some reason.
I'm sure they're busy. It's a Thursday, so it's a grand jury day, I guess. They're getting other stuff coming in. Let me check thing. Ms. Nelson's doing a quick check. Let's see if she can scare up a number. And then where did Ms. Rios go? Oh, talking to a client. Okay.
Thank you, Your Honor.
You're welcome.
What's happening? Your face looks.
Oh no, Miss Nelson's gonna check, so she can get a number. I think, I think we may have been able to get something together for global.
Okay. It's gonna be like with a text airplane.
Well, that's my, maybe moves to 5, so.
So like, I'm gonna do my accent for about 9 years to make it after the beginning and date. Probably have. I just think that we all stop like. Social friends, that's good.
My thing is for the. I'm almost supporting, so that was some people. Chairs.
Yeah, okay, yeah, we're going with it.
Okay.
We just need 5 more pieces of child.
For you. For you.
We have,
I have a
Patterson.
and have a 5.
Yeah, then Patterson.
And you're on both of those things.
Yeah, do you think we're gonna go on those?
I think Cotton was before.
Why?
Because Cotton was is impossible.
I mean, I don't care both of them. I just think.
I would. Separate.
Okay.
Two things that were. And Cotton is actually also. Patterson has absolutely. Yeah.
So if I'm choosing which to prep, I'm gonna prep that and cotton first. Okay, focus on cotton, and then we also have Jane. Oh, man, she's so emotional. She really is only pleased with 3 years. I know it. Take her down to 2.
She shot them.
He looked fine in the video after walking and stuff. By what? Now you're going under. Now you're kidding.
Really good shot. Stomach. He said he got last twice. I saw him like that shot once. He was twice.
But he was coming at They're wrestling over the gun. But then they were wrestling, and maybe she got her shot. Shoot. I'm happy. But you see her kids, you see the kids come over. They were here that day, and I'm done. Just so she had. Yeah, where you been right there?
Judge,
Yes, ma'am.
I got an email from Miss Hankins on, Angela Johnson. She had her, mental health eval. So, is she?
We needed that so she could make it to PDC.
Yeah.
Yeah.
So I was gonna ask, Miss Hankins, but not even the whole document.
That's so fast.
No.
Is it Dr. Browning?
It came from his neighbor, actually.
I wasn't gonna hear you.
Who's that? Oh, that's their social worker,
Yeah.
right?
Whatever comes out movie.
So what about? Yeah. So he's.
Oh, NAFCare did it. Okay, that's great that they do it. I didn't know that happened.
So, do we need to bring her back, or we can just be?
No, please do just that. And then let us know, is that sufficient? Hopefully PDC or GDC, or who does it go to? DCS or?
I sent it to Officer Brown. Officer Brown sends it to our coordinator for the action. They didn't depart that rush.
Okay.
And then, but it goes to their alternative.
And then they'll look at it and say, now we know what we need to manage. Okay, that's all we need. If it's the green light, full speed ahead. If they say, based on this diagnosis, we cannot take her, then she needs to come back because we have to come up with a different sentence.
I guess not a situation.
Judge, well, Judge, I don't get assigned the documents. Yeah.
If it relates to something that, I did, so let's say on June 29th, I did it, and you get it out on July 2, that should go to me. But if you're asking, hey, on July 8th, if I get a probation warrant from one of my colleagues, where do I send it? The answer is to Rhapsody Little, who is the Deidre Nelson for Judge Ellerby. And if you're going to stay with the docket, I'm going to introduce you to everyone. We'll have a time where we just need to find out who's staying put. And if so, we ought to have donuts or something. Okay. Yeah, then we need to arrange something so that just everyone can say, hey, and then you at least have a face to go with the name. But Ms. Little is the Ms. Nelson for Ellerby. And she may say, I only want things hand delivered, or they need to be faxed, or I trust email will work, but you'll have the person to whom you can, with whom you can have that conversation.
And it doesn't. I think the condition, I think it's completing the probation without any issues with conditions and completing the probation.
I don't think that they're going to be, that is a very efficient chambers. And so I think they're going to want e-file, e-sign, all that kind of stuff.
Yeah. Yeah. We just need to get some. Yeah. Okay. Cheese. Those were nice, it was very. No, it's not like this. Those are the. I want to get a grant. I mean, if you're okay, this is like. It's probably very okay. Yeah.
I didn't be cross.
No, I just. I'm a good 18 first couch and it.
All right, we did not get any, it was not that we don't have it, it's that no one is responding. So it's same holding pattern you're in. I'm fine if you guys want to take a 15-minute break, start at 3. I'm also fine saying, let's take Mr. Wells's pleas.
Doing that, I just want to take it.
Ms. Smith wants to get out of here. All right. Well, that's the lead we'll follow. She's got places to be. Yes, sir, please. Ms. Rivers, are you ready? Okay, let's get on the record with Mr. Wells. Good afternoon, Mr. Wells.
Good afternoon, sir.
Mr. Wells, you are here to potentially enter pleas in 2 cases. 25 SC 006805. That case charges you with aggravated assault and a couple other things. The other case, we don't have the case number yet. You were originally charged in a case with child molestation. The state is agreeing to dismiss that. We'll get that on the record in a little bit. And they have accused you in a new document that charges you with cruelty to children in the 2nd degree. Is that your understanding of what we're doing?
Yes, sir.
Okay. I don't have a case number yet for that. I'm going to call it the case of 26 SC unknown. You're comfortable with what the allegation is and moving forward with a plea in that case, not having a specific case number. We'll be real clear on the record. You are charged with doing X to person Y on this date. Ms. Williams will get all that in the record. The only thing we don't have is that's case number 1234. You understand that?
Yes, sir.
You're okay going forward?
Yes, sir.
Ms. Rios, are you all right going forward in this posture?
Yes, sir.
All right, and we may get that number in the middle of the hearing and we'll add it. Otherwise, I'll make sure that Ms. Rivers gets it into the record, whatever that case number is, 26 SC unknown. Given that, Mr. Wells, Ms. Williams is going to put you under oath in just a moment and then ask you questions about your rights and about these cases. We may hear a bit from Ms. Smith, who's seated behind you. She's the prosecutor handling the case involving the aggravated assault. Ms. Williams has your case involving the cruelty to children charge, and she's going to handle most of the things for the state. Please answer all her questions truthfully and completely. Also, please let Ms. Rios or me know if you have any questions about anything. Will you do that?
Yes, sir, I will.
All right, Ms. Williams.
Thank you, Judge. Mr. Wells, could you please raise your right hand? Do you affirm that the testimony you shall give in the matter currently before this court shall be the truth under penalty of perjury?
Yes, ma'am.
Thank you, sir. You may lower your hand. Could you please state and spell for the record your full legal name?
Xavier Marquise Wells, XAVIER MARQUIS WELLS.
Thank you, sir. Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there a medication that you normally take that you have not been given today?
No, ma'am.
How old are you?
25.
What is the highest level of education that you have completed?
High school.
And did you receive your GED or diploma?
No, ma'am.
Are you therefore able to read, write, and understand the English language?
Yes, ma'am.
Ms. Rios, on behalf of your client, do you waive formal reading of the indictment?
Yes.
Sir, do you understand that you are currently charged in the case that the judge is referring to as 26 SC unknown, which was originally indicted? Okay, so there's two different things. Let me slow myself down. So you're originally indicted under case 25 SC 007589. Do you understand that in that indictment, you were charged with 1 count of child molestation?
Yes, ma'am.
And then the state has moved to dismiss or null pros that indictment. Do you understand that?
Yes, ma'am.
And we have reaccused the case with 1 count of cruelty to children in the 2nd degree.
Yes, ma'am.
Have you had an opportunity to review or discuss with Ms. Rios the rights that you were giving up by entering a plea of guilty today?
Yes, ma'am.
Have you had enough time to speak with your lawyer, Ms. Rios, about all the facts and circumstances known to you regarding the charges in the indictment and in the forthcoming accusation, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss the case with your attorney?
No, ma'am.
Are you satisfied with her services?
Yes, ma'am.
Ms. Rios, on behalf of your client and for the purposes of this plea, do you waive any and all defects in the indictment, including any with respect to his name?
Yes.
Mr. Wells, have you been arrested on these charges?
Yes.
Ms. Rios, the state is unaware of any outstanding warrants related to these charges. Do you know of any?
No.
Mr. Wells, has your attorney advised you of the minimum and maximum sentence for each charge you are pleading to?
Yes, ma'am.
As to cruelty to children in the 2nd degree, the sentence range is 1 year to 20 years. Sir, do you understand that this is a negotiated plea of guilty, which means that the state and your attorney will make a sentence recommendation to the court, but the court does not have to accept that recommendation. The court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other.
Yes, ma'am.
At this point, Ms. Smith, did you want to place information on the record regarding sentence ranges?
Yes, so for count 1 in the indictment ending in 6805, that ranges from 1 to 20 years. And for count 2 in this case, the state will be null processing this count, which is a possession of firearm during the commission of certain felonies.
So 1 to 20 for count 1, count 2 is dismissed.
Yes.
Thank you.
And Ms. Smith, does that count dismissed for the purposes of today's?
That is correct. Yes, dismissed for the purposes of today's plea.
So for the forthcoming accusation, Your Honor, the state is recommending a sentence of 5, serve 1 for cruelty to children in the 2nd degree.
Okay. Is that a global offer? It's going to be the same from Ms. Smith or 2 different sentences?
2 different sentences.
Okay. All right.
Ms. Smith, do you want to put your?
Yes, for count 1, the state is recommending 10 years to serve 1 with the balance probated.
Got it. So a year to serve, and these are to run concurrently with each other?
That's correct.
So the operative part, 1 year to serve, more probation in the 805 case than in our unknown number case.
Yes.
Okay.
Judge, there's also some special conditions of probation. Would you like for me to name those now?
Sure.
The state is recommending for the defendants to stay away from the incident location, to have no contact with the victim, to complete 25 hours of community service, and for the defendant to complete an anger management course.
And for my case, Your Honor, the state is recommending, first of all, that Mr. Wells stay away from the victim, Azaria, Azariah, Burt, B-U-R-T. And that was really the only special condition for that particular case.
Okay.
Mr. Wells, having heard the terms of the recommendations, do you wish to proceed with this plea?
Yes, ma'am.
Not saying that you will ever be convicted of any crime again, hopefully you will not, but should you ever be convicted of another crime, do you understand that this plea that you're entering today could be used to increase or enhance sentencing on that future conviction, and that applies to any state, any jurisdiction, including the federal courts?
Yes, ma'am.
Are you on probation or parole?
Yes, ma'am.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
Yes, ma'am.
Do you understand that neither the court, your attorney, nor the district attorney's office has anything to do with parole, the Department of Corrections, or Board of Pardons and Paroles, and no one can guarantee parole, no matter what anyone has told you?
Yes, ma'am.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, and your right to receive, possess, or transport a firearm.
Yes, ma'am.
Do you understand that by pleading guilty to felonies, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
I'm not going to go over the individual rights that you are waiving as to both cases. And so this would apply to both cases. Sir, do you understand that you have the right to plead not guilty?
Yes, ma'am, I do.
Do you understand that if you plead not guilty, this matter could proceed to trial?
Yes.
Do you understand that by entering a plea of guilty, you waive any and all defenses, including but not limited to any mental health offenses?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up each of the following rights? Do you understand that you are giving up the right to trial by jury,
Yes, ma'am.
as well as the right to remain silent and not incriminate yourself,
Yes, ma'am.
as well as the right to confront witnesses against you,
Yes, ma'am.
as well as the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case,
Yes, ma'am.
as well as the right to the presumption of innocence,
Yes, ma'am.
as well as the right to testify on your own behalf and to present other evidence,
Yes, ma'am.
as well as the right to subpoena witnesses and compel the production of evidence,
Yes, ma'am.
as well as the right to have the charges against you proved by the state beyond a reasonable doubt.
Yes, ma'am.
And finally, you are giving up the right to appeal the conviction of these charges after trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, ma'am.
Ms. Smith, what are the last four numbers of your indictment?
6805.
As to indictment 6805, how do you plead to that charge?
Guilty.
And as to the forthcoming accusation, how do you plead to that charge?
Guilty. Under Alfred.
Okay.
Both or just
No,
one?
That's the
The,
cruelty to children.
got it.
Okay, so let me take a step back. So as to the forthcoming accusation, are you pleading guilty because you have decided that it is in your best interest to do so?
Yes, ma'am.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes, ma'am.
Are you asking the court to accept your plea as guilty under offer?
Yes, ma'am.
Is this guilty plea and guilty under offer plea, are those freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Please understand that for both cases, you do not have a right to appeal directly from your guilty plea. But if you believe there is some error in your plea, you can apply to the appropriate appellate court to request a discretionary appeal. The discretionary appeal procedure is outlined in OCGA section 5-6-35. You understand that?
Yes, ma'am.
You understand that the judge is going to give you further instructions about withdrawing your guilty plea and when and if that can be done?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Do you understand that the appeals and filings that we have just discussed must be filed by your attorney unless you are representing yourself?
Yes, ma'am.
And finally, do you understand that unless your attorney is substituted or permitted to withdraw, your current attorney, Ms. Rios, will represent you until either the end of the current term of court or 30 days from today's date, whichever is later?
Yes, ma'am.
Mr. Wells, that concludes all the information and questions that I have for you. I will now turn to providing the court with a factual basis for the forthcoming accusation. Your Honor, in July of 2025, on the 21st, Azaria Burt, AZARIAHBURT, alleged that Mr. Wells, who is her maternal half-brother, they were at their mother's home, which is within the bounds of Fulton County. And she stated that she was awake with one of her other brothers. They were playing video games. She went to go to the restroom. When she exited, Mr. Wells was standing outside of the restroom, and he pulled her into his bedroom. At that point, she alleges that he exposed himself. I did speak with Ms. Burt. I also spoke with her father. As just a quote of something that she said, as I was explaining to her what this process would look like.
How old is she, or what? I mean, it's just a few months ago. How old is Ms. Burt?
She's 16 now.
Okay.
Okay. So she basically told me that, this is a quote, that nothing can change what happened to her. She said that she did not want to think about it anymore, and that she wanted to move on. Her father expressed that she had been having some issues in school and issues with family, but that has now gotten better, and he didn't want to stir anything up. So they are not present today. But she has been affected by this. I think she's trying to move past it in the best way that she can. I certainly understand that. So I think because of that, it would obviously be difficult for the state to present that at trial without re-traumatizing Ms. Burt, and we certainly do not want to do that. And so this is a fair outcome given that information. Regarding Mr. Wells' criminal history, Ms. Smith is going to speak more about that because there's also another piece in this plea. But I would just ask you to accept the plea as negotiated, and I would then inform the Burt family of this outcome.
How do they intend to navigate family situations? Mr. Wells, for 9 years, is going to need to, I guess the sentence is longer in Ms. Smith's case. So in your case, it's 4 years. But for 4 years, he's going to need to stay away from Ms. Burt, his half-sister. And I'm less worried about the impact on him, but if their shared mother says, I want everyone around for my birthday, I mean, they're aware that a consequence of this is that if mom wants Mr. Wells to be around, then she needs to not have Ms. Burt around, and obviously vice versa.
So Ms. Burt is currently residing with her father full time.
Okay.
And so I did, sort of talk about that. Her father said that, if she does not want to be in that, want to be around her mom or want to be around anywhere Mr. Wells would be, that it would not be a problem.
Okay.
So they have contemplated that.
Okay. Got it. Ms. Smith?
Yes, Judge, regarding the facts and circumstances in my case, if this case were to proceed to trial, the state would show that on July 29th, 2025, so around 8 days after ADA Williams' case, officers of the Atlanta Police Department responded to an altercation call at 507 Joseph E. Lowry Boulevard Northwest. That's in Atlanta, Georgia, and also Fulton County. That location is a JJ Groceries, corner store. When they got there, the officers spoke with the clerk, Mr. Crenshaw Bodu. First name is spelled Krishna. Last name is Boddu. When they got there, the victim told the officers that 4 males came into the store around 8:08 p.m. One of those males that entered the store was the defendant in this case, Mr. Wells. When they came, he noticed that Mr. Wells was a person that was in the store earlier that day that he suspected of taking ice cream from the store without paying. When Mr. Wells got in line to purchase the items that he had, the clerk, Mr. Bodu, he did kind of confront, or he talked to told Mr. Wells that he knew that he had stolen the ice cream earlier that day. A verbal altercation started. This eventually ended up with Mr. Wells pulling a gun out of his waistband and pointing it to the clerk in this case, basically going back and forth with him, saying like, I didn't steal anything. Stop playing with me before I shoot you, or along those lines. That's not verbatim. There's like a plexiglass or something in between the clerk and the defendant in this case. However, we did obtain video footage of this incident that occurs just as it is explained in the police report. So we can see on that video that Mr. Wells pulls out a gun from his waistband, points it at the clerk, and tells him that if he doesn't stop playing with him, that he will shoot him. At this time, Mr. Wells did leave the store. The officers put out a warrant for Mr. Wells' his arrest, and he was originally arrested for aggravated assault. And that's the facts and circumstances of my case. I did speak with Mr. Bodu, the clerk. He said that his cousin owns the store, but it's like more than one location. And he's not really at the location where this happened at that 507 Joseph E. Lowry Boulevard. However, he's been back before, and he believes that Mr. Wells lives in the community because he's been in the store a couple of times. And when Mr. Wells was arrested for this arrest, his brothers or family members or friends would come in the store and say, like, it's you, you're the one who put my brother in jail. And they would come back and kind of antagonize him. So he feels as though he's okay with the state's offer. However, his biggest concern is that he just wants the defendant to stay away from the store. And if he happens to see him at another location, to kind of leave that store and leave him alone. But that's the statement I got from the victim in this case.
Why dismiss count 2? Often you will do 5 serve 1 on count 1 plus 5 probation on count 2.
Yes, Judge. A part of the negotiations in this case, we kind of took into account that the year previously, Mr. Wells pleaded guilty to a possession of a firearm during, and if he was to plead guilty to this charge, it would be a 10-year mandatory sentence.
Oh.
Because we believe that the 10 serve 1 was a reasonable outcome or resolution in this case, we just decided to no across that count 2.
Got it. I didn't realize that would be his second or subsequent, so it would make it a 10 serve case, not a 10 serve 1.
Yes, Judge.
Okay, thank you. Ms. Simpson, I think Mr. Wells is on probation in a 23 SC case. Has there been any revocation in connection with these?
It was my understanding that that would be handled, as a local resolution with 2 pleas. I spoke with Ms. Rios, and agreed that my recommendation would be to revoke the first offender status, because this is a first offender probation, and to rescind him according to the negotiated.
Okay. Ms. Smith, do you have any objection or a different view as to what should happen with the case is 23 SC 188045?
No, Judge.
Okay. Ms. Williams?
No, Your Honor.
Okay. Ms. Rios, if I were to revoke first offender status and resentence him to, I don't know what the charges were. It's sealed. His part is sealed. Oh, I do. It's 3 counts of aggravated assault.
I think it's 2 assault.
Oh, and a gun.
During.
That's right. He and 2, I was able to find the indictment because one of the 3 defendants, it's not sealed. But for Mr. Wells, it is sealed. 2 ag assaults, India Andrews, and 2 Wellses. Is Jadarius your brother? Cousin. So 2 Wellses and an Andrews shot at 2 people, and then somehow all collectively they had a gun. So, okay. All right. Ms. Rios, any issue with that?
No, Your Honor.
Okay. In terms of criminal history, I'm aware of just that one conviction that is the first offender. Do you have anything else? No?
He got 2 cycles, so he had a Judy that was only.
Okay.
But the ag assault was the first offender. Possession of not a firearm, I think it says suspended sentence on the GCS.
Okay.
That's it.
All right. Thank you. Ms. Rios, tell me about Mr. Wells and what you think should happen.
Yes, Your Honor. Mr. Wells is 25 years old. He had a difficult life. He was in foster care for, I believe, 11 years, or since he was 11 years old. 11 years. 11 years, sorry. 11 years. His mom has 11 children, so it was a little difficult in that household. He wants to put this behind him and do good. He plans to get on getting his GED. Before this, he was working at the Westin Hotel downtown as a houseman, and he was told that his job is waiting for him when he gets out. I believe they've been calling his mom and saying he's a good worker and they want him to return. And so I'm asking for you to accept the global negotiation that worked out with everyone. He did the Alfred plea because the other case with his sister, he has a different version of what happened. He might not actually talk to family members who are saying a different story, that she wanted to go live with her dad. It was a whole different thing. They've been here at the last court date, his siblings and his sister.
Mr. Wells's siblings.
His sibling, his mom, and his sister has reached out to me several times. So this was a kind of fast court date that we put on. So that's the only reason that they're not here.
Okay.
He does have family support. He doesn't have a problem staying away from his sister, and he understands this was the best situation just to resolve everything.
Okay. Do you have any kids, Mr. Wells?
Yes, I do.
How many?
2,
2. How old are they?
5 and 2.
5 and 2. Okay. And do they stay with is it one mom or 2 moms?
1 more.
One mom. Do they stay with their mom
Yes.
in the Atlanta area?
Douglasville.
Okay. Close enough. I mean, they're not in Texas.
Yeah.
Okay.
And also, I did complete anger management course since I've been incarcerated as well.
Good. Here at the Fulton County Jail?
Yes, sir.
All right. Do you have any questions about anything we talked about?
No, sir.
Anything you want to add?
No, sir.
Okay. Is India a female, India Andrews, or is that a guy?
That's the mother of my children.
Oh, she was a defendant in this case. Oh, okay. So your kid's mom and your cousin were the defendants.
Yes, sir.
Were Zabora Brown and Malcolm, McCollis Esters, were they people you knew?
No, sir.
Okay. All right. And Ms. Burt, you obviously knew your half-sister and then store clerk. Got it. All right. Well, Mr. Wells, I find that there is a factual basis in both your cases. In the case ending in 805, that's the situation at the convenience store on Joseph E. Lowry. I think the state could prove its case with the video, et cetera. Never a good idea to pull out a gun in a convenience store. You never know if the clerk has a bigger gun or there's an officer in there or someone else gets freaked out that a gun's pulled out, and then people start shooting and it's a whole nother story than just pointing a gun. But more importantly, you don't get to have guns anymore. You're done with that. Because of the case with the mother of your kids and your cousin, no guns. It's not worth it. I appreciate that you may end up, when you get out, being in a neighborhood that's not super safe, carry a baseball bat or something, but you and guns mixing will lead to legal troubles, and it's just dangerous. And you've passed up on that opportunity. Your other case, 26 SC unknown. I also find there's a factual basis. And by that, I simply mean if Ms. Burke came in and told the jury what she told the police, they could choose to believe her. I appreciate that it's probably more nuanced than what I heard from Ms. Williams. But we're not having a trial on it. You're saying, you know what, it's in my best interest to take this plea. I'm going to do that. And I hear you. And it may be that there's more to that story, but there's enough there for me to accept your plea. I also find that your 2 pleas are knowing and voluntary, meaning you've understood what we talked about and no one has forced you to enter these pleas. Do you agree with that?
Yes, sir.
All right. Ms. Williams, can someone in my office sign this mystery 26 SC unknown once we get that document?
Yes, Your Honor. Thank you.
All right. And for you, Ms. Smith, can we sign for you on the case ending in 805?
Yes, Judge.
Ms. Rios, can we put your signature on both documents?
Yes.
And Mr. Wells, can we sign for you indicating your plea in both cases?
Yes.
We'll do that. Ms. Williams, you are moving to dismiss or null pros 25 SC 007589, assuming this plea goes through.
Yes.
All right. And Ms. Smith, you're just dismissing count 2 of the case ending in 805.
That's correct.
Ms. Rios, is Mr. Wells, I didn't see it in the docket, and so it may not have been filed, or it's just slow in getting there, any waiver of indictment?
I already signed.
Okay, it's going to be in that new docket then. It's not obviously in the old one, but you've waived on behalf of Mr. Wells his right to have the cruelty to children charge presented to a grand jury.
Yes, sir.
All right. And Ms. Rios, are you waiving any due process notice rights that Mr. Wells has concerning a revocation in the case ending in 045?
Yes, sir.
All right. Then here's what I'm going to do, Mr. Wells. In the case ending in 805, that's the pointing the gun at the store clerk, I'm sentencing you on the only count that remains to 10 years to serve 1 year with a balance on probation, and you'll get credit for the time you've been in. You've been in for a while. Special conditions of your probation. Number one, get your GED. That will only help you as you try to move forward. Number two, you need to stay away from that convenience store. Number three, you need to stay away from Mr. Modu. So if you see him in a different convenience store, he happens to be in there, you got to leave that. You can go to another convenience store, but if he's the clerk there, you're done being in the store that day, and you got to come back when he's not a clerk. You'll need to complete 25 hours of community service and either get probation proof of the anger management course you took. Hopefully you got a certificate or something, hold on to that. Or you'll need to take another anger management course. We can never have too much of anger management. That will be your sentence in that case. I will set a behavioral incentive date in that case of May 1 of 2029. That's 3 years down the road. If you've done all the things you need to do, probation has gone smoothly, no revocations, no arrests, and they want to close that out a little early, they can, because 9 years is a lot of probation. But this second case you picked up where you were pointing a gun at someone, and it sounds like, I don't have any of the info, but in the case with Ms. Andrews, one of the three of you is actually shooting at someone. It's not just pointing a gun. Even worse. We'll see how this plays out, but 9 years is still a long time to be on probation. In 26 SC unknown, your accusation, I'm sentencing you to the only count in there, which is cruelty to children in the second degree, to 5 years to serve 1 year, balance on probation. That sentence will run concurrently, same time with your sentence in the 805 case. Special conditions of your probation: 1, get your GED. 2, no contact with Ms. Burt. That's a little tricky because she's not a stranger to you like the store clerk. She's a family member. But that means that if you're going to go visit your mom and your mom says, hey, Azaria's here, you can't be there because Ms. Burt is there. You have to go away from a situation she's already in. And that's it for that case. One more piece. In 23 SC 188045, because of your 2 new convictions, I'm going to revoke your first offender status and resentence you in that case. Count 1 will be 1 year to serve. Count 2 will be 1 year to serve. Count 3 has to run consecutive. It will be 5 years. It will be probated. So it's 6 years to serve 1 year with the balance on probation, no longer first offender status, and we'll maintain, like, I can't see what your sentence was in that case because it's sealed, but I know at a minimum it will be to have no contact with Zabora Brown or McCallus, MACALOUS, Esters, ESTERS. You'll stay away from those 2 people. And I think we'll leave it at that. Did you have anything else, Ms. Smith?
Yes, I was just going to say for that case, it was a 15-year probation. So it was 10 years for the ag assault and 5 years consecutive for the possession during.
Okay, the one that we're revoking things on?
Yes.
Noted. Anything else, Ms. Williams?
No, Your Honor.
Okay. Ms. Rios?
No, Your Honor.
Okay. Mr. Wells, you will I don't think you'll go into state custody, given how much time you serve, so probably the remainder of your time will be at the county. When you're released, you're gonna need to report to probation. You should already have a probation officer from this case from 2023, but either way, you'll need to report. Do we need to, are you gonna give him some reporting instructions? So Ms. Simpson's gonna meet with you back in lockup just to give you some reporting instructions. The basic rule is within 48 hours of your release, you got to make it to the probation office to say, here I am, and they will connect you in all three of your cases. There'll just be one officer for all three cases. Do you know where the probation office is?
Yes, sir.
Where is it, do you think it is?
It's on Memorial Drive.
Right, it's like 2 blocks from here. It's on Memorial Drive. You're going to be living in Fulton County when you get out?
Yes, sir.
With whom do you stay?
I'm staying with my father.
Okay. And your father is different from Ms. Burt's father?
Yes, sir.
That's the half part. Okay. All right. That's it. Thank you. Anything else? No? Thanks, Ms. Rios. You are lining up the cases. Tomorrow, nothing. Nothing criminal. We have a emergency TRO hearing. A church is supposedly going to be foreclosed on, so they're coming in to say,
On a church, that's ungodly. That's.
you have to talk to the bank. It's a little more than that.